Everybody have a seat, please. Thank you. The November 14th, 2023 Liquor Board hearing is now in session. All the hearings of the board are now transcribed and stored electronically. These transcripts, serving as minutes of the hearing, are accessible for review by scheduling an appointment with the board. I now make a motion that the transcript from the previous board hearing held on October 10th of 2023 be accepted as the board's minutes for that date. And I ask for a second.
I second the motion.
Thank you very much. We have a second. All those in favor?
Aye.
Aye. All right, that passed. Mr. Praley, I'm going to turn the meeting and the hearing over to you, sir.
All right, thank you, Mr. Chairman. I'll be very brief tonight. Good evening, everybody. My name is Jimmy Praley. I serve as the board's attorney. At the beginning of every meeting, I make a couple brief announcements. First, the commissioners before you tonight are part-time public servants. They all have outside interests. When they know of a conflict of interest or the appearance of a conflict of interest, they'll recuse themselves, but due to the number of cases that are called every night, and the ability for the members of the public to appear in support or in opposition of any matter, it would be impossible for each and every commissioner to know whether or not a conflict exists. So when your case is called, if you think that one of the two commissioners sitting up here tonight has a conflict, you need to make that known at the time your case is called. Otherwise, we'll proceed forward under the supposition that there is no conflict. Second, the rules of this board provide that for the purposes of judicial and administrative economy, the board can have counsel rule on the objections of evidence, the admissibility of evidence and objections if counsel are present and objections are made. Because the board handles many cases at each and every hearing, this assignment allows us to expedite the hearings. So in some cases, rather than the chairman looking to me advising the chairman, I will simply make a ruling on evidence or objections, and my ruling will be that of the chairman and the board. Finally, you will note that Commissioner Duffy is not present tonight. He's down in Florida on a family matter. So, getting back to my first announcement, if you do believe that there's a conflict of interest with one of the commissioners, in all likelihood, your case is going to have to be postponed tonight. So, with that, we will turn it over to our Chief Inspector, Jim Ford, who can call the first case. Inspector Ford, please.
Thank you, Mr. Praley. Welcome, everyone. Our first case of the evening is Angel's Share Wine and Spirits. Angel Share, LLC. Caitlin Hall, Managing Member. Joseph Baldwin, Member. Tamika Robin Adair, Clerk.
Mr. Katz, will you waive the reading? Yes. Thank you.
Thank you, Mr. Katz. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. And starting with Detective Middleton, if you could state your name and address, please.
Good evening, Board. Detective Middleton, Anne Arundel County Police, 1061, assigned to Western District.
David Katz, 2410 Evergreen Road, Suite 105, Gambrills, Maryland.
Samuel Chaney II, 2701 Middle Neck Road, Odenton, Maryland, 21113.
Joseph Baldwin, 808 Homestead Lane, Crownsville, Maryland, 21032.
Thank you.
All right, thank you, everybody. Detective Middleton, if you could provide us with a statement of facts, please.
Yeah, good evening again, Detective Middleton, Anne Arundel County Police. This was October 8th of this year, 2023, approximately 4:30 p.m. Detective Mountcastle and I were working Operation Save, conducting alcohol sales compliance checks of retail businesses. We directed a confidential source, 20 years of age, to enter Angel Share Wine and Spirits at 2299 John Hopkins Road, Suite E as in Edward, and Gambrills, located here in Anne Arundel County, Maryland. We observed the confidential source enter the business. The CS went into the store, picked out a six-pack of Miller Lite beer, took it to the front counter. The confidential source was given official Anne Arundel County funds and was able to purchase the Miller Lite beer from the clerk. The clerk did not ask the CS for identification. The CS exited the business, immediately turned over the alcoholic beverage to myself and Detective Mountcastle. I know through my training and experience that Miller Lite beer is an alcoholic beverage. Detective Mountcastle and I entered the store, identified ourselves as police officers, and identified the clerk as Tamika Adair, date of birth of 4/17/84. Ms. Adair advised that she had been working at the store since May of 2023 and advised that she had not had any alcohol awareness training. A photograph was taken of the clerk, the Anne Arundel County liquor license, and a photograph was taken of the Miller Lite beer. It was subsequently destroyed. Ms. Adair was cooperative. The store was not busy. A copy of the report was then forwarded to the Anne Arundel County Liquor Board. That would be my statement, other than the source, confidential source that we do use. We do go to MVA to verify, have a certified copy of a driving record that verifies her date of birth of May 27, 2003, which would make her under 21.
All right, thank you, Detective. Mr. Katz, do you have any questions of Detective Middleton based on that statement of facts?
No question.
No questions, okay.
Okay.
Mr. Chairman.
Could somebody tell me, is Miss Adair in the courtroom or in the hearing room?
Well, we've been unable to contact Miss Adair, and we don't represent her. We represent Angel Share.
Okay, now I appreciate the answer. Mr. Baldwin, is Miss Adair still employed by you?
No, she's not. She was let go immediately.
Okay, I just want to make it clear that she was summoned and she didn't appear. And normally what would happen is we would postpone this case. She would be re-summoned and the license would be charged with a violation of cooperation, failing to make sure. But I understand Mr. Katz's situation. I think we can go ahead and proceed in this case because she's no longer employed, but you do understand that that might leave a little gap in your defense if you have one. Just want to make it clear.
No, we understand that and appreciate that. As a preliminary matter, we would note that Caitlin Hall had been excused, who's also on the license, just to note that as well.
Sure. Let's turn it back to some questions here to keep the record straight. Mr. Chairman, do you have any questions of the detective based on the statement of facts?
No, I don't. I don't have any questions at all at this time. Thank you, Detective.
Commissioner Snoops, any questions?
No questions.
All right. Mr. Katz, we'll turn it over to you. You can present your client's defense at this point. You can do so by way of proper testimony or a combination of both. We'll turn the floor over to you, all right?
Yes, thank you. Appreciate the opportunity to be here. Unfortunately, I'll just start with, on behalf of my client, that there really is no defense of being proffered. But we certainly want to provide evidence that moving forward, that my client's taken significant steps to ensure that something like this does not happen again. I'll start with a couple of points. Since being cited, Ms. Adair was immediately terminated. She had only been an employee for 3 months, and at the time, the manager who was on duty was currently in the back training another new employee. For what that's worth, we have since all 12 employees are currently tip certified, but we went ahead and had them all get recertification. So all 12 employees have now up to date. Well, not that they weren't up to date, but have new tip certifications, which I could provide the board. So all 12 employees are now recertified. The establishment has purchased an Age Visor Touch ID scanner, $1,100 investment. So this particular scanner is used by TSA, and now every ID is scanned. We have roughly 50 pages of scans that have happened since the date of the violation. I won't share that with the board, but, you know, I did bring an example of all the new scans that have happened since the violation. Lastly, I would say that Sam Chaney, general manager of the stores, here presently, you know, obviously takes this violation extremely serious. You know, he intends to implement internal secret shoppers to ensure that all of his clerks do comply with this requirement, and with the age verification requirement. So on top of this, on top of the ID scanner, on top of recertification of all the new employees, he will be doing an internal investigation, if you will, ensuring that all new clerks do use the ID scanner moving forward. And we proffer that as, you know, respectfully request that the board take all this into consideration in implementing any penalty or fine.
Thank you, Mr. Katz. Mr. Chairman, any questions?
I do, Mr. Katz, and thank you. But I think the first question is, the scanner that was purchased, is it one that authenticates?
It does, and I actually have the user manual, copies of the user manual if you'd like to see.
If you have a copy,
Yes.
we'll take it. Some of our scanners out there, just so everybody knows, do not necessarily authenticate. They just basically check the date of birth and let you know if it's over 21 or not.
So, the printout that I have of all the recent scans, it does show the age authentication as well, if you'd like to see that.
Okay. Well, I think the fact that you have the system such as this shows that you're making an effort, and that's much appreciated. I do have a question, though. Miss Adair, the clerk, at the time of the compliance check by the detectives, she had been working there since May, but wasn't alcohol awareness trained. Am I correct in?
She was only there, she actually only worked for us for 3 months. She had actually only worked.
Yeah, I'm gonna yield over to Sam.
She was actually only with us for 3 months. She wasn't there since May. When she was hired, she told us she had alcohol training, but I never got the paper from her, so. But it is a requirement. Every single employee, once they make 2 weeks, we make them go through alcohol certification.
You say 2 weeks?
Yeah, I used to do it the first day, and then I realized I was losing a lot of money.
Yeah.
So,
Well, you don't have any restrictions that specify an amount of time that these certifications have to be completed.
it's generally 2 weeks, and it's generally, no one's allowed to touch the register until they go through it. So it's the first 2 weeks of training. We make sure they're going to make it at the store, and then we make them go through certification. Tamika coming from a more corporate environment and telling me that she had it, it was my mistake of not actually telling her to bring in her card and keeping it on file.
She was previously employed with
A&A.
A&A.
AA, not A&A. Yeah.
AA.
Understood.
Yeah.
Okay, thank you. That's all the questions I have at this time.
Commissioner Stoops, do you have any questions?
I don't have any questions.
Mr. Katz, anything you want to add before it goes to the board for deliberation and decision?
No, that concludes.
All right. Mr. Chairman.
Okay, thank you. Just to make sure that you understand and everybody listening to me tonight, I do appreciate the efforts that you've taken in order to try to avoid another situation like this. But it's my understanding that this is the second violation since 2019. I think February 24th, there was a a non-compliance check done by the Anne Arundel County Police Department in which you were, I believe, fined in that case, found or adjudicated. That makes this the second offense. Hopefully never to see a third. But I think what I'd like to do is, under the circumstances, and you do need to make sure these people are certified. And if they're not, then you need to get them certified. So what I'm going to do is I'm going to make a motion that we put a restriction on the license, and it's a really simple one, and that is that any and every employee who deals with alcohol must be certified within 30 days And if they fail to do that, then that could be a violation, so please be careful of that. You do it within 2 weeks, so it shouldn't be a problem, but I'd like to put it on the license that happened. I'm also going to make a motion that, listening to the officer's report and the circumstances, that we find you guilty in this particular case, and I'm going to make a motion that we fine you $1,000 for each of the 2 offenses, a total of $2,000, plus you'll pay any additional administrative fees or court costs, as they're referred to sometimes. And that's in form of a motion. Looking for a second.
I second the motion.
Okay, thank you. All those in favor?
Aye.
Aye. Okay, Mr. Katz, thank you very much. Gentlemen, lots
you,
of
Mr.
luck
Chairman.
in the future.
Thank you, everyone. Calling the next case, Ocean Wine and Spirits.
Waive reading.
Thank you, Mr. Brown. All right, anybody wishing to testify, please remain standing and raise your right hand. Please remain standing. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. And once again, we'll start with Detective Middleton.
Sorry. Detective Middleton, Anne Arundel County Police, currently assigned to Western District.
Detective Charles Cepeda, also assigned to Western District.
Salom Habib, 745 Mammoth Court, Millersville, Maryland 21108.
26B Holy Road, Flamboni.
And I'm sorry, sir, did you state your name?
Your name?
My name is Jong Yun.
Great, thank you. Thank you, everyone.
All right, thank you, everybody. Detective, if you could please provide us with a statement of facts.
Yes, sir. This was again on October 6th of this year, 2023. This was approximately 6:40 p.m. Detective Malcastle, Detective Cepeda, and myself were working Operation Save, conducting alcohol sales compliance checks of retail businesses. We directed a confidential source, 20 years of age, subject to enter the Ocean Wine and Spirits located at 7703 Baltimore Annapolis Boulevard in Glen Burnie, Anne Arundel County, Maryland. I'll just say that before we checked with Motor Vehicle Administration to verify our CS age so that the date of birth was 5/27/2003, which would make her under the age of 20, or the age of 20. The CS went to the store, picked out a 6-pack of Modelo beer, took it to the front counter. The CS was given official Anne Arundel County funds, was able to purchase the Modelo beer from the clerk. The clerk did not ask the CS for identification, but did ask the CS if she was old enough. The CS answered yes. The CS exited the business and immediately turned over the alcoholic beverage to us. I know through my training, knowledge, experience that Modelo beer is an alcoholic beverage. Detective Malcastle and myself entered the store, identified ourselves as police officers, and identified the clerk who's sitting over to the left, Mr. Yun. He advised he had been working at the store for approximately 3 years and that he has had the alcohol awareness training. A photograph was taken of the Anne Arundel County liquor license, the Modelo beer, and it was subsequently destroyed. Mr. Young was cooperative. The store was not busy, and this copy of the report was forwarded to Anne Arundel County Liquor Board.
Mr. Brown, any questions?
You said they were cooperative, correct?
Yes, very cooperative.
That's all the questions I have.
All right.
Okay, thank you. I have a couple questions. It's my understanding that the clerk had been there for approximately 3 years, and he has gone through or had gone through the.
Oh, this is still their case. You're
Yeah,
asking us questions? This is the officer's
We're just
case.
asking questions of Detective.
I
right now,
apologize.
based
Thank
on
you.
his reading.
That's okay. I just want to make sure that we...
I'm getting confused. I'm putting my questions ahead of mine. No, I have no further questions from the officer. I think it was pretty clear. Thank you.
Commissioner Snoops, do you have any questions?
No questions.
All right, Mr. Brown.
Mr. Prelli, I move to dismiss. there's an inconsistency in this report, and I don't know if I should believe the police officer who's a friend of mine, who I like, and I find is an honorable person, who's relying upon information from a third party, or I should believe this confidential informant or source. In 42 years, well, I've been doing this for 47 years, but I can only remember back some of them. 42 years, I have never seen a confidential source lie. They walked into that store, and I'm assuming they tell the truth. And that's the problem. The policy of this board forever has been, you walk in, they ask you if you have a license, ask you your age, and you walk out. You don't say, I'm old enough, or I'm 27, or I'm 52, or I'm 16. In this case, if you read the report and listened to the report, I'm looking at line 1, 2, 3, 4, 5, 6. The CS was given official Anne Arundel County funds, was able to purchase some Modelo beer. The clerk did not ask the CS for identification, but did ask the CS if they were old enough. The CS answered yes. That is a blatant lie by a representative of this board, and it's almost an entrapment. And that's my concern, is that this board doesn't look to go against licensees and cause a violation, create a situation where they send somebody in to lie. That CS made a mistake. That CS should never have answered that thing. She should have said, I don't have ID. She should have said nothing at all, and she should have walked out the store. But she should have never turned around and lied to that clerk. The clerk, did he make a mistake by not asking for an ID or not getting it? You're darn right he did. But did he follow up on that by asking her, are you old enough? Because you looked at the thing, and I looked at the person's ID. I'd be surprised if you would believe that she was 20 years old, but that's beside the point. I didn't see her date of birth. I don't know if she lied to the MVA because she was trying to get out easy. I don't know what the situation is here, but you have an inconsistent report in front of you where the person who bought the alcohol says they're over 21 years of age. So based on that alone, this is not a violation. And I'm asking this board to dismiss it because you don't want a policy out there where the individuals who are confidential sources for the police are allowed to go in and lie. That is wrong. That is totally wrong. And this board follows the rules. You know, Mr. Chairman, we've been getting memos from you that this is not right. We need your affidavit in here. We need this document here. You are getting up to date every licensee in this county. A lot of our chagrin when we do it because we've got to do so much to get it done. But you are getting it, and you are a rule follower. This is not a rule that was followed. And I don't know how anybody can condone her walking in there and saying that she's over age and she can buy alcohol. That is, as I did a whole memo on entrapment, and I said, I'm not going to submit a memo on this because there are issues that can come into play on this. But the issue is for fairness. And I argued this before in the past on different things, and you've accepted that argument. But right now, when you all are the rule creators and you follow the rules and you want us to follow the rules, then you all got to follow them too. And I'm asking that this case be dismissed because the report is inconsistent. You have a police officer that says one thing who isn't the person, therefore it's a hearsay statement that he has. Then you have the confidential source saying something else, which says, I'm over 18, I'm over 21, I'm sorry, I can buy beer, is what they basically said when they walked in there. And I think this is a grounds for a dismissal. And I'd ask the board to consider dismissal of this before we go any further.
Thank you, Mr. Brown. Thank you, everyone. Just wanted to make sure procedurally I was doing this correctly. Listening to Mr. Brown and everything that's been testified to, I'm going to deny the grounds for dismissal in this particular case. And I can go into some of those reasons in a moment, but I think the most important thing is that your request is denied.
But now it's your turn to present your defense. So you can do so.
I would call.
Anything else?
I've never gotten this far before. I never had to do this. I mean, what do I do?
It's your turn now, Mr. Brown. We'll turn it over to you.
And she's laughing at me. She knows that I'm telling the truth.
We're laughing with you.
Well, with you.
Yeah.
Not
with me. I'm sorry, with me. I appreciate that. First of all, the person immediately to my left is the qualifier. He has nothing to do with the business. He's never there, but he has everything to do with the business because without him, the business doesn't exist. But he was not there that night. Now, what I'd like to do is ask Mr. Yun to testify and lean forward into the microphone. Mr. Yun, you were the individual that served the alcoholic beverage that night. Is that correct?
Yes.
Yeah, you have to answer yes.
Yes.
I couldn't hear you. I'm sorry.
Over there, over there.
Yeah.
Yes.
Yes. Okay. And you asked the woman if she was old enough, didn't you?
Yes, I'm asking.
And what did she tell you?
She said yes.
And based on that, did you serve her? Did you serve her?
Yes.
Did you ask her for ID?
No.
Why?
Because there was a lot of line, then it was busy.
Okay.
Yeah.
How old did she look to you?
About 27, 28.
Okay.
Looks like.
And had she been in there before? Do you know?
No.
You don't know.
No.
Okay. Have you been tip certified? You're certified for the alcoholic beverages, right? Yeah, you've been certified?
Yes.
You told the police officer about 3 years. Is that accurate?
I was liquor business for a long time. Then I think it's fire, but a long time ago for alcohol. Well, I don't know English, but
Did you recertify?
Yeah.
Okay, all right. And you've been working there for 3 years now?
yes,
Okay. Have you ever had a violation before?
no,
Okay. And do you have a ID card reader in your store?
yes, I have.
But-
My side is I got two cash register. One side I have one, my side is not.
And why were you working your side that night?
It's busy. Then I make it for line. Then
And when you asked her the question, are you old enough?
yes.
Did you think she was going to lie to you? Or you think she'd tell the truth?
I'm trust to her. No, yeah, I'm trust her. Yeah, that's why I said for her.
You know that's not always the best thing to do, don't you? Okay. But did you intend that night to sell alcohol to an underage person? Was it were you trying to break the law that night? Did you want to break the law and sell to somebody under 21?
No.
Okay. Did you think she was over 21?
Yes.
That's all the questions I have.
Thank you, Mr. Brown. Mr. Chairman, any questions?
I do. You took the time to ask the young person, the confidential source, if they were old enough, but you didn't ask for any ID. So when that person walked up to your counter, what would you normally do if you suspect that they may be under 30 or 35 or?
I was every time I check ID, but that time my mistake. I know that.
Okay, well, thank you for admitting that. A question, if I may, is this Mr. Habib sitting here?
It is, Mr.
Yes.
Habib's my
Okay,
left.
and you're the president of the company, sir?
My name on the license. Actually, I am not the owner. I sold the business, but my
Okay,
name on the license. Yes.
He's a qualifier.
Yes, I
And he
am.
serves as president as a qualifier, yes.
okay. Are you certified, trained in alcohol awareness?
Yes.
So you have an up-to-date, it's not expired, correct?
No.
Okay, very good, thank you.
That would be our case, Mr. Chairman.
Okay, I have no more questions at this time.
Commissioner Snoops?
My only question would be, granted, the CS didn't tell the truth, but there's a heck of a lot of 18-year-olds that don't tell the truth when they want to get some alcohol. So it kind of sets a precedent. And if it was another 18-year-old coming into your store and you ask them that, now you have a slew of them coming in because that's all you do. You don't get ID, you just ask. So it is important to get ID and not just ask.
We will never argue that, Ms. Snoops. They are ordering the second ID for the ID scanner. And it's the ID scanner that they brought in here before that they bought on the first one, very expensive. They're going to have a second one coming in and taking care of it that way so it doesn't fall through. That scanner is necessary in order to even open the cash register. But quite frankly, you made a mistake. You don't expect them to lie. And so that's basically our case. And if mitigation, we're ready to be heard whenever you want. But I would renew my motion to dismiss because I think at this point, you have 100% of the evidence in. You have the police officer and the clerk agreeing on what the woman said. The question is she under 21 or over 21? And we don't know that completely. We should have asked for an ID, but they shouldn't have lied. And I have a major problem with that. If my client came in here and lied to the police officer, you'd be writing him up right now for non-cooperation. Okay? That would be exactly. If he lied and said something that wasn't correct, he'd be non-cooperation. We'd have a major violation against us on this license. And you have a CS who either lied to the police officer about the age and falsified her driver's license, or lied to this individual when she went in there. And I don't think that's the way you want to catch people. You don't want to do that. And I'm just, based on that, I'm asking that you consider this and you tell them they were wrong. If you want to find them responsible, but give them a reprimand on this. If you have to, at the worst you're going to do, because I know what the history is. You'll repeat the history to me in a couple of minutes. I know it completely. But the issue here is not, you're not out to catch people this way. Maybe that's the new policy. You're going to have everybody coming in line now from now on. I don't know. But Ms. Snoops, I don't think that's the intent. They don't want to see us to lie. So I don't know what you do about that. So we have an arm of the law who walks in there and sets this guy up and lies. He was wrong. He did the wrong thing, but she lied. That cannot be condoned. And as a result of that, I think a warning has to go out that it can't happen again this way. And I think instructions have to go to the police that she cannot turn around. When she gets asked for an ID or asked her age, she walks out the door. Or he. You don't turn around and lie to make your job and to satisfy your supervisors that are waiting outside for you. Interesting thing also, his son is a confidential source for the police. Okay, I didn't know that till Detective Middleton told me, and then I said, "Is it true?" And he said, "Yeah." So the son works with them.
You don't want to give away his identification.
I didn't
Mr.
give
Brown.
away his identification. Huh?
I'm sorry.
But that's the freaky nature of this whole thing. So it's not like we don't understand the rules.
Okay, I am going to deny your motion again to dismiss, so we're going to go ahead from there.
Mitigation, Mr. Brown? Anything else you want to add?
What medication? Unfortunately, they've been here 2 years in the past two times in the past 4 years before you. Last time was 2021 on it, so they were here 2 years ago. Different clerk who's not there, all that. This is one who's been there for 3 years, has a good background and experience, understands the rules, is qualified and everything. And he was as straightforward as anybody could be with you. He was right up. And I mean, this wasn't an intention to violate anything at all, or he wouldn't have asked the question. And he trusted. And that's the problem. He used bad judgment on that. Not that he didn't try to ID, but he used bad judgment. And I mean, they've been here twice, like I said before. This is a family business that the man has there. And we're just asking the board just to do what we can. We're spending the money for the second scanner to put on the second cash register. They're very solid in the community. They have the signs up on what you have to do. If you see all the pictures in the report, you see that they posted the appropriate signs in every place. And they're cooperative. That's about the best I can tell you. I hope that's enough.
Thank you, Mr. Brown. Mr. Chairman.
Okay. Thank you, Mr. Brown. This is the third offense. The first one was September 6th in 2019. Second one was August 19th of 2021. And of course, tonight is the third non-compliance check violation.
Every 2 years, we try to be consistent.
Well, you are.
This is the last consistency that we're done.
Well,
we're done with your consistency. We're not going to make your job that easy for you from now on, so we're done.
I would love to believe you, Mr. Brown, and I do. Of course, you know what they say about the proof and pudding and all that, but I think under the circumstances, Mr. Habib, do you spend any time in the store at all?
No.
All right, just a qualifier, I understand.
Mr. Habib used to own the restaurant, the grocery store right next door. He sold the liquor store a long time ago. So until recently, he was right next door in case they needed everything.
Yes.
But he decided at his young old age, he wants to retire. So he sold his grocery store and his food. And they had the best Arabic food in town, but not anymore.
Okay. Mr. Yun is the only employee or
No.
sole? No?
No. How many employees do you have
No,
there?
I got 3 employees there. And both owner, the wife and the husband, so 5.
Are all your employees alcohol awareness trained?
I think so. Yes. I should.
Your board can tell us and we'll find
Yes,
out.
the law say everybody have to have, yeah.
Yeah. All right, what I'm going to do is make a motion. And because this is the third offense in about a 4-year period, I'm going to make a motion that we find you guilty of the violation. And because it's a third offense, I'm going to make a motion that the fine be $1,500 per charge, 2 charges, a total of $3,000. And cost. I'd also like to add just a warning. This is your third offense in 4 years. I can't tell you how serious it would be if you come back in here with another one in any period of time.
We still have 2 years, yeah.
That's my argument, not yours.
That's right. It was well said, Mr. Brown. All right, I've put that in the form of a motion, looking for a second.
I second the motion.
Thank you. All right, all those in favor? Aye.
Aye.
Okay. Thank you, Mr.
Chairman,
Brown.
members.
Thank you, everybody. You're dismissed.
Thank you, everyone. Calling our next case, Sun Valley Liquors.
Board President will waive a reading.
Thank you, Mr. Bittner. Everyone wishing to testify for or against, please come forward. Remain standing and raise your right hand, please. Gentlemen, thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. Detective Middleton.
Mr. Chairman, members of the board, I'm Richard Bittner. I represent the licensee who entered a general denial to both allegations.
Starting with Detective Middleton, if you could state your name. and address,
Detective
please.
Middleton, Anne Arundel County Police, Western District.
Detective Spada.
Detective Cepeda, also Western District. I apologize.
Thank you.
Sorry.
Sir.
Bimal Katwala, 1562 Rutland Way, Hanover, Maryland, 21076.
Sir. Name and address for the record.
Raju Padia, 773 Raymondwood Drive, Landburn.
Thank you very much.
And if I may, Mr. Chairman, this is the clerk, and I have advised him of his Fifth Amendment right, and he's indicated to me he does not wish to offer any testimony in this matter.
Okay, great. And Mr. Sinclair was excused from this, correct?
Yes.
All right. Just want to make.
Thank you for that, and we waive any appeal for his absence.
All right, thank you, Mr. Bittner. All right, Detective, can you please provide us with a statement of facts?
Yes, sir. October 6th, 2023, approximately 6:15 p.m.
Objection, reading.
Overruled.
Detective Mountcastle, Detective Cepeda, and I were working Operation SAVE, conducting alcohol sales compliance checks, retail businesses. Directed a confidential source, 20 years of age subject, who we verified through Maryland MVA records. I have a copy of certified driving record for age. CS entered Sun Valley Liquors at 7965 Baltimore Annapolis Boulevard, Glen Burnie, here in Anne Arundel County, Maryland. We observed a confidential source enter the business. When CS went to the store, picked out a 6-pack of Miller Lite beer, took it to the front counter. CS was given official Anne Arundel County funds, was able to purchase the Miller Lite beer from the clerk. The clerk did not ask for identification. CS exited the business and immediately turned over the alcoholic beverage to us. I know through my training, knowledge, experience that Miller Lite beer is an alcoholic beverage. Detective Mountcastle and myself entered the store, identified ourselves as police officers, and identified the clerk as Raju Padhayas, May 15th of 65. Mr. Padhayas advised that he'd been working at the store for 4 years and he has had the alcohol awareness training. The manager on the scene was identified as Mr. Bimal Katwala, and a photograph was taken of Mr. Padhayas and the Anne Arundel County liquor license and the Miller Lite beer, and subsequently destroyed. Mr. Padhayas was cooperative, the store was busy, and a copy of the report was forwarded to the Anne Arundel County Liquor Board. That would be my statement.
All right, thank you, Detective. Mr. Bittner, questions?
Yes, thank you. Detective, you didn't see what occurred inside the store, did you?
I did not.
And you indicated the store was busy and the employees were cooperative.
Correct.
Now, this was part of an Operation Save sting, is that right?
Well, it's a compliance check.
A compliance check. Now, does the department, anybody, have any written policy regarding when compliance checks are undertaken?
No.
How they're undertaken? When, where, how? I mean, there's no written policy regarding what you do, period. Is that right?
Correct. Just follow the rules and regulation of the police department as far as,
Confidential source.
you know, dealing with the confidential source. But as far as save, no, there's no specific regulation.
The confidential source, any training provided to that source?
Yes.
And what's that training?
More for safety and, you know, that type of thing to go, you know, would just direct them to go inside the store and attempt to purchase an alcoholic beverage.
No written policy on how the confidential source should be dressed, or that's one question, how they should be dressed.
There's no policy for safe.
And likewise, am I correct in understanding no statistics are kept regarding your activities?
We do a list of the stores that are checked and forwarded to the health department and the liquor board now.
I'm sorry, so you do maintain a list of stores that are checked?
Yes.
And that list is sent to the health department and to the liquor board?
Correct.
Any information provided to the retailers when they successfully pass the test, pass a check?
I believe so. Now they were going to send out a letter for a pass that was letterhead from the police department, the liquor board, and the health department that, you know, states that they did pass the compliance check.
But that hasn't occurred yet. That's still in process.
No, it's in place.
It's in place? You're
Yes.
sending those out now?
Yes, we did it. We started that last year.
I remember you telling me you were going to do it, so good. Statistics kept on who passes and who doesn't?
Yes.
And how would one obtain those statistics? You keep them, or?
Probably have to make a request to Central Records at the police department.
Now, this confidential source that you used on October the 6th, she wasn't searched before she went into the establishment, was she?
We searched them before and after. That's our policy for dealing with confidential sources.
That wasn't in the report anywhere. You didn't read that.
No,
Right.
but that's the question you asked.
Okay. But that's your policy, and you believe you did that on October the 6th.
Yes, that's what I stated to you before about what policy exists. The policy as far as dealing with confidential sources, we follow the policy of that, but there's no specific policy for SAVE.
Now, you mentioned that you have the certified MVA copy for the source with you?
Yes, sir.
And if I may? So, and this is a certified copy with a photograph, the driver's license photograph of the person that was utilized on October 6th. Is that right?
Correct.
I'm going to move that into evidence if the board please. Now, thank you. Detective, let me show you what would be marked as licensee's exhibit number 1, if the board please. You would agree with me that that photo accurately represents the appearance of the confidential source that was sent in to Sun Valley Liquors on October the 6th.
Yeah. Yes.
Move this photo in. Now, you would agree with me, would you not, that this woman looks markedly different than her motor vehicle driving record picture?
Well, it's not a very good picture. It's black and white. It's not very. It's hard, yeah, I can't do a good comparison between that and the color photograph on her.
But you can tell in the black and white photograph that she's wearing glasses and her hair's put up, right?
Correct?
She's wearing jewelry and a dress, right?
I don't have
Sorry.
Sure. Glasses, yeah, and jewelry.
Detective, thank you, and I would like to thank you for your cooperation with me in providing the information before the hearing today, as well as the hearing today.
Any more questions, Mr. Bittner?
No.
Okay.
Not a Detective Middleton.
Mr. Chairman, any questions?
No. Thank you.
Commissioner Stoops, any questions of Detective Middleton? Nope. All right, well, Mr. Bittner, we will then turn it over to you. You can present your client's case by way of proper testimony or combination of both, but it's yours.
At this time, just for the record, I'll make a motion for verdict.
Okay. A motion will be denied. We'll let you proceed forward.
Mr. Chairman, members of the board, we don't have any case that we want to present in terms of the defense, but we would like to be heard in mitigation.
Sure, go right ahead, and then we'll turn it over to the board for questions.
Thank you. As you heard at the outset, my clients were cooperative, polite and cooperative with the officers as they've always been. That's their nature. That's the nature of this establishment. It's a family-run store, a community neighborhood store. On the day in question, you heard that the store was busy, exceptionally busy, my client advises me, and what they were concerned about and why Bill was actually in the office watching out through the two-way mirrors was that they have been the victim of a number of gang shoplifting events. And they had a number of young people, they believe they're students, that have been coming into the store, 4, 5, 6, 7 people at a time, kind of bum rushing them. So that was what was going on at the time the officers were there and this confidential source entered. And most respectfully, you can see how she appeared. You don't need color to see how different she appears when she went into the store as opposed to her picture from the MVA photo. And I believe the record reflects that she's 20 years, 5 months. She's underage, okay? But I point that out to the board that this woman was not someone that immediately appeared underage to me. And the clerk advised me of that. The owner advised me of that. And they just simply, with the distraction, Mr. Passari committed an error, made a mistake. He's TIPS TAM certified, has been. Prior contact with the board, this establishment has, not this clerk, not this licensee involved in those. And this is an establishment, Mr. Chairman, members of the board, that is extremely busy. On a slow day, I'm advised they have somewhere in the neighborhood of 400 point of sale transactions. Friday and Saturday, 800 points of sale. No testimony from the officers that this establishment has a reputation, that they were called there because of problems with the establishment, some type of routine. Yet we don't know how that's arrived at, and I've asked the board to consider formulating a more precise policy of how places are chosen and why other places aren't chosen. And certainly the board would recognize that one of the main point sources of alcohol to minors is not minors going into Class A establishments and purchasing retail from the clerk. It's being procured from family and friends. It's being procured by the 21-year-old who's in a date with a 19-year-old and is purchasing it in a restaurant, which is, I understand, Sting operations do not go to Class H's. They don't go to Class B's. I've yet to see that case before the board. And I think the board should be concerned about that, the general policy. But as we get to this particular incident, this particular establishment, it makes no sense, Mr. Chairman, Commissioner Snoops, that Mr. Koala would put his business and his future deliberately at risk by trying to sell to minors. The profit margin simply isn't there. This six-pack of Modelo has a profit margin of about 60 cents. There's just no money in it. It's just no money in it. And we know that because, again, I have to reiterate, this is not an establishment, to my knowledge, and I'm happy to be corrected, where the board or the police are getting calls from the public that this is a point source, that people are stopping there before they're going to the high school football game. None of that. They don't sell single cups. They don't sell single 16-ounce beers. The establishment, you may recall, backs up to a wooded area, and there's kind of a dirt road that passes through to the community. There's no problems there with consumption outside. The establishment is well policed, it's well operated, but for these human errors. And I would ask you to take all of that into consideration and issue an appropriately meted out fine. As indicated, everybody here is tip-stamp certified. They have signage up. They have a card ID. When I ask my clients about the use of the card ID, they tell me that, quite frankly, they don't use it all that often because if they see someone, they have a policy. If you look under 30, they ask for cards. That's why this woman was not asked, aside from the distraction. And what I'm advised is when they ask someone, most of the time that person just walks out if they're underage. That maybe they get 3 or 4 fake IDs a year. Very, very infrequent does that happen. They're doing everything humanly possible. They recognize the consequences. They know what it means to be here. They don't want to be here. This is not the type of client I like to have come back. They get that, and I'd ask you to consider that. Thank you.
All right. Thank you, Mr. Bittner. Mr. Chairman, questions?
Yes, I have a few. First of all, Mr. Bittner, just for the record, I believe you made a comment about Class H or Class B establishments not being alcohol awareness checked. I mean, as far as compliance, non-compliance?
To my knowledge, right? I have not heard that SAVE had gone in
I will
there.
correct you.
Please.
The SAVE unit has been to establishments that are a restaurant, and they have had violations. Granted, it's not as many as Class A's, but just for the record, and so you're...
Thank you for bringing me up to date on that.
Yeah, no, we understand that there is a need for that too, as well as for Class A operations. I guess my next question is addressed to the one licensee, Mr. Bimal Katwala. Are you alcohol awareness trained?
Yes, sir.
You have a card that is active, correct?
Yes.
Okay. And do you know if Mr. Sinclair is alcohol awareness trained? I understand he's not here.
He's just on the license for the...
He's the qualifier. I don't believe he's ever in the building.
He's never there as a...
Well, I know Mr. Sinclair. Anybody that's been in this county for any length of time knows Mr. Sinclair. My concern is that the restriction on your license says licensees and any employee who dispenses and serves alcoholic beverage must be certified in a state-approved alcohol awareness training course. I'm also looking at the management agreement, and I don't see, of course, you being a licensee don't have to be on a management agreement, but I don't see Mr. Sinclair or anybody else there. If Mr. Sinclair is not alcohol awareness trained, he needs to be.
Okay.
Because he's a licensee.
I'll make sure that.
And I'm not so sure if Harry would.
I'll take care of it next week as soon as he's back from his
All right.
He has health issues, or he's with his daughters right now, so as soon as he's back, I'll take care of it.
Okay. It is, just so you're aware, it's part of the restriction. It's on the licenses. and
No problem,
you're
I'll
aware
take care of it.
Okay. I guess my next thing is a question. Do you remember the last time you were compliance checked, whether you passed or failed?
I'm not sure on August 24th. I'm not sure who it was, police department or somebody from liquor board or inspector. There was a young girl that came in, and he's the one who was serving her and carded her, and she left without purchasing or showing her ID. And then we have a group of retailers that, if we have like somebody shoplifting and stuff like that, we share information. Like, we had somebody that tried to pass a fake credit card or whatever. So, and on that same chat group, the same person's information was given that this person was in the store without an ID and was asking for liquor. And not just one, but that person went into 5 or 6 different stores, and the truck that was outside was the same truck. I'm not sure who was with that person. So we have a feeling that it was either a police department or somebody from liquor board or health department. I'm not sure.
Okay, thank you. I have no further questions.
Commissioner Snoops, any questions?
I have no questions.
Mr. Bittner, anything you want to add, sir?
No, thank you for your time.
Mr. Chairman?
Okay, thank you. Scrutinizing and looking at everything very closely, we rarely look past the 5-year mark when we're looking at past violations. This particular establishment, though, between 5-year and a 10-year had 2 violations. But let's say we don't even consider that. You've had 2 within the last 5 years. One was August 14th of 2021, and the other was August 29th of 2019. This makes it the 3rd violation within 5 years, and it makes it 5 within 10 years. And I'm only pointing that out because, it's important you understand that whatever you're doing is not enough, evidently. And what I'm going to do is I'm going to make a motion at this time. That motion is because this is your 3rd violation within a 5-year period. I'm going to find you guilty, and the fine for that is $1,500. That's $1,500 per charge. There's 2 charges. That's $3,000 plus whatever the administrative cost is. And like the other case we had that had 3 violations, I can't help but take a moment and just make sure you understand how imperative it is for your license that this doesn't continue. I don't know what you need to do, and I'm going to leave that up to you and perhaps some advice from Mr. Bittner, but you need to do something because evidently the clerks are not doing what they should be doing. Now, granted, she may look over 21, but most establishments have a rule or a guideline that says between under 30 or 35, you're going to card them. Maybe that's something you should consider.
We do have a practice of that. Like, we're a neighborhood store, so most of my customers are repeat customers. So whenever we see an unfamiliar face and person don't look 30 or below, we do ask for ID. People get offended too, but as like Mr. Bittner said, we had like 3 incidents in that week where we had a group of teenagers walked in the store and ran out with products. And when we call the cops, all we do is like we have to wait 15, 20 minutes, 30 minutes for them to get at the store, and all we get is a case number and nothing else happens. So that makes us, that gets really frustrating. And
I understand. And unfortunately, I have a motion on the dais that I'm looking for a second.
I second the motion.
Okay, thank you very much. All those in favor?
Aye.
That passes. All right.
Thank you.
Again, lots of luck. Please be careful.
all right,
Hopefully we don't see you in here again for something like this. Thank you.
thank you.
Thank you very much for your consideration.
Thank you, Mr.
Y'all
Bittner.
stay safe.
All right, bringing our next case, La Fogata, Bellows Companies LLC. Thank you, Mr. Lyman. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. And I'm going to defer to our administrator, Mr. Aronson, for the oath.
I do.
Chief Inspector Jim Ford, Anne Arundel County Liquor Board.
Inspector Joseph McKernan, Anne Arundel County Liquor Board.
My name is Brian Lyman, Lyman, on behalf of the licensees and the company.
My name is Ricardo Jr. Bayo Alvarado. My address is 8137 Harold Court, apartment 3A.
Sean Hicks, 1758 Woodtree Court Circle, Annapolis, Maryland, 21409.
Ricardo Bello Serrano, 421 Merriman Court, Annapolis, Maryland, 21401.
Gabriel Bejarano, 145 Westway, Greenbelt, Maryland, 20770.
Thank you.
I'm sorry if I may. Can I get you to repeat your name one more time?
Gabriel Bejarano.
Gabriel. Okay. Thank you.
Okay, Mr. Chairman. All right, well, this being an inspector complaint, we will turn it over to Chief Inspector Jim Ford. Do you want to read first, Inspector Ford, or?
For this one, I believe we're just looking to Inspector McKernan.
Okay.
Yeah.
Joe, if you could provide a statement of facts, please.
All right, on August 26, 2023, at approximately 1:10 a.m., I was doing a follow-up check at La Bodegate, a restaurant located at 3029 Solomon Island Road, Edgewater, Anne Arundel County, Maryland, on a dancing complaint. They were given a warning by this officer, or this inspector, back on July 8, 2023 at 12:45 a.m. I gave the warning to Manager Milton Cordes. Also, through my investigation, Chief Inspector Jim Ford gave him employees, managers, 3 different warnings. One on July 14th, 2023 to Juan, the manager. Tuesday, 6/20/23 to Sean Hicks, a member on the license. And on Monday, July 3rd, 2023 to Sean Hicks by way of email, and Mr. Hicks responded to that email. On the night or the morning of Saturday, the 26th, I pulled into the parking lot and noticed strobe lights were going on and the DJ was playing music. I parked the car, walked up to the building, took 4 photographs of people dancing by the tables. I also took a picture of a floor area that appeared to be a dancing floor area, and there was one male on there dancing by himself. And then on September 7th, I issued a citation, section 4.16 for illegal conduct, failure to comply with license restriction, dancing. Violation date was 26th of August, 2023. It was served September 7th at 1:35 p.m., given to the member Sean Hicks. Okay, and that's it.
That's it? All right, thank you. Mr. Lyman, questions?
Thank you. Has the board been provided a copy of your report dated 26 August 2023?
That's, you should have it right there.
Right, but has the board been provided a copy of the report?
Yes.
Okay. Does the report include the 4 photographs that you took?
Yes.
Okay. And if I show them to you, can you identify them for me and for the record? I've got a copy here, but I'm just trying to understand what was part of your report to the board.
And Mr. Lyman, for the record, this is Mr. McKernan's report that you're questioning the board whether they received?
Correct. I've got a copy here of a single-page report.
Okay.
And do you have photographs with you?
Yes.
That were provided? Could you show those to me? That might speed things up a little.
But it should be pretty large, so.
Okay, so you have several photographs here. Actually, you have photographs that are labeled 1 through 6.
Okay.
No, 1 through 8.
Yeah, this is not regarding the dancing situation.
Okay, so of these photographs, can you show me which photographs you contend show dancing going on in the establishment?
When I walked in, photographic number 5 was clearly dancing by himself.
Is that, and can you just point to the individual in the photograph for me?
Took his shirt, has tattoos on his body with no shirt on.
Okay. And these photographs from outside the establishment,
Correct.
do they show dancing? Can you tell me what individuals you observed?
This girl right here was dancing, and this gentleman, this would be picture number 2. There's a female, black hair, looked like a black sleeveless top, and looked like blue jeans.
Okay. And how about in that photograph? That's labeled number 3.
Number 3, I was standing at the window, is a Hispanic male, brown shirt with shorts on, and he was dancing.
Okay. And how far apart were these photographs taken in time?
Probably within, between the first photograph and the last photograph, probably within 5 minutes.
Okay. And can you describe the definition that you're using for dancing?
Dancing, it was my understanding, is any movement, moving their body.
Okay, so for example, someone stands up to walk to the bar, they have to move their body. Is there some other movement that you're cueing on that would, you would say that would qualify as dancing?
Going with the music.
Okay. And did you observe that on the morning of Saturday, the 26th of August?
Yes, I could hear the music from outside the building.
Okay. What was the first time that you arrived on scene at the establishment?
All I know is approximately 1:10 a.m.
Okay. Do you know the total time that you were at the establishment on the 26th of August?
Probably left 1:50 a.m.
At 1:50 a.m., so approximately 50 minutes?
40, 50 minutes, correct.
Less than an hour, though, correct?
Correct.
Okay. At your prior visit, you indicated that you interacted with manager Milton Ordonez. Do you recall that testimony?
Correct.
Okay. Was he cooperative during that interaction?
Very cooperative.
Okay. Was the staff cooperative the evening that you visited on the 26th, or the morning of the 26th?
Very cooperative.
Okay. And did you indicate to them at that time that you would be writing a violation?
I did not.
Okay. Why is that?
I wanted to discuss it with my boss, Chief Inspector Jim Ford.
Okay. And what factors did you consider when deciding to issue a violation?
Pass warning, cooperation.
All right. And on prior occasions, can you describe what led to the prior warnings, if you know?
Prior to the first warning, I noticed a crowd late at night, so I drove through the parking lot and just did an observation through my vehicle, and I left. And then found out that dancing with the DJ was going. I didn't figure out what was on their license. Then I found out that they weren't allowed to have they were allowed to have a DJ, but no dancing.
Okay. I think you indicated that you thought, in your opinion, that there was a dance floor or a dance area. Can you describe what that is?
Yeah, you got the pictures. Picture number 6, 5, and 6 will show you which normally would have tables in those areas, and its tables are pushed away, and it created enough room to put numerous people could be out there dancing.
Okay, but you only saw this one gentleman when you entered the establishment, correct?
Correct.
Okay, and there was nobody else dancing as you entered the establishment? Or, I'm sorry, after you entered the establishment, it was just this gentleman? You did not see the young lady with the dark hair that you pointed out from outside, correct?
I seen them moving. I seen other people. I didn't take pictures of them, though.
Okay, so your testimony is that there were more than one person dancing when you entered the establishment. Is that correct?
Correct, but not on the dance floor, by their tables.
Okay. What staff member did you interact with on the 26th, if any?
It was, let me see, it was the Juan Vasquela, or however you say his last name.
You spoke to manager Juan Vasquez?
Yes.
Okay. And did he indicate any issues that evening to you as far as managing the crowd or anything?
Yes, he said they had two unexpected groups of people. One of the groups was for a celebration of life for 3 Hispanic people that were shot back in Annapolis on July 26th, and they didn't know they were coming. A lot of them were from out of state. Plus, there was a surprise birthday party they weren't aware of that showed up to celebrate a birthday party.
Okay, and he indicated that given that number of people that they would have planned to schedule having more security on site had they known that they were going to have a crowd like that, correct?
Correct, that's what he said, yes.
Okay. Do you have any reason not to believe that that was the case?
Not at all.
Okay. And I'm sorry, I didn't look at the calendar. Is Saturday the 26th actually a Saturday, or are we talking this is a Friday night event that went into Saturday morning?
I have to look at the calendar. I believe it was a Friday to a Saturday.
Okay, and so the 26th reflects midnight, the clock turns over, correct?
Correct.
Or the calendar turns over. Thank you. I don't have any further questions.
Mr. Chairman, any questions?
No, I have no questions of the inspector.
Commissioner Snoops?
No questions.
All right, Mr. Lyman, turn it over to you.
Thank you. We've got actually 2 violations on the docket, and we're going to enter a general denial of the dancing provision,
Sure.
and we're going to admit the violation that a licensee was not present for the last hearing. And I don't have a case in defense to put on necessarily. I would like to be heard in mitigation on the dancing violation and make argument.
Sure, we'll see if the board has any questions for your clients first, and then obviously you can do follow-up questions, and then you can put on a case of mitigation. Mr. Chairman, do you have any questions of Mr. Lyman or the licensees that are present tonight?
No, I don't. I'm glad to see Mr. Serrano showed up this time.
Yeah, I would like to say I'm sorry, but I was working and I was very busy at the moment, so I couldn't make it. Forgive me, please.
That's all right. I'm glad you could make it. I guess one of the questions that keeps popping into my head is I've had the opportunity to be at this location over the last 2 years, I guess it was. Yeah. And I noticed tables appeared to have been moved and the floor opened up. And what was the reasoning for that if it wasn't to allow people to dance?
So let me respond, and then I'm happy to allow Juan Vasquez, the manager on duty that night. I'm happy to allow him to respond. If you'd like to hear him directly, I'm happy to let him talk too. But
well, we got to get him sworn in first. I don't think he was sworn in.
Well, I don't believe so.
How about the other managers?
Mr. Ordonez?
Stand up just in case you solemnly declare, raise your right hand. Solemnly declare and affirm under the penalty of perjury, the testimony you're about to give is the truth, the whole truth, and nothing but the truth. You can just state your name and address for the record.
Milton Ordonez, 1713 Harvard to Crest Drive, Edgewater, Maryland, 21037.
And mine is Juan Vasquez, is 5601 Exeter Street, Churchill, Maryland.
All right, sorry to interrupt you, Mr. Lyman. We'll let you go ahead and respond.
That's fine. My understanding is that the tables were pushed by the patrons themselves, and that because of the understaffing, they had an issue with retrieving the tables and pushing them back, and basically policing the crowd this evening. Mr. Vasquez, would you like to add anything?
Yes, I try to tell them it's the birthday party.
Please stand.
Come stand up here. To see together. That's what they push the table away, so they want to sit as a family together, and that's the only reason. Always we keep at the middle of the table. And that's all I have to say.
Okay, thank you. Thank you, Mr. Lyman. I have no further questions at this time.
Commissioner Snoops, any questions?
No questions right now.
All right, Mr. Lyman.
So let me start with the failure of a licensee to attend at the last hearing. As you heard, Mr. Serrano is deeply apologetic. He is the licensee. He has entrusted management duties of this establishment as the managing member of the company to two managers who I think are very capable, and they split most of the time that the restaurant is open. They've just had a staff loss, but Mr. Serrano is actually a chef. He used to be a chef at Carroll's Creek. He tried to be himself in the restaurant business a little bit under the prior iteration, the other trade name of this establishment, Los Chaparritos, and there was a tragedy in the parking lot at this establishment that I'm sure the board is aware of, and rebranding was required, and new management has been brought in to try to address the clientele and the business operations and the business plan overall as a restaurant. I was on the fence about taking this case. I obtained these clients yesterday. I was contacted by one of the managers on Friday afternoon, and I was nervous. I was very frank with him. I said, you have a situation here where there's a reputation for this location, for this license, for this LLC, and you're in peril. And basically, I read them the riot act about the situation that they're in and the circumstance. And frankly, I was shocked that this was the violation that was a problem for the establishment. But I'm not shocked after meeting with these LLC members, with the owners of the business, and with these two managers. In the 2.5 hours that I spent with them over the past 2 days, they have been highly responsive to me, and I trust that they are going to make the appropriate changes to the operation, to the marketing, and to the business plan about how this restaurant wants to move forward. I've described to them the risks of having large crowds late at night. I've described to them the risks and the problems of advertising and having DJs and live entertainment play music, and having their clientele and their customers have the expectation that there may be dancing available. And frankly, they've answered that since this violation has occurred, they've lost a lot of those customers, and they're adapting. They're changing their business model to try to really become more of a family restaurant during the week, and they're going to try to limit the engagement from folks who maybe expect to come out to a club scene or a dance scene, because that's not what their license allows them to do. I've been impeccably clear with them that they do not have that privilege. They understand fully, and Mr. Hicks, I believe, was in asking Mr. Aronson about the possibility of applying for a dancing license, but I've described to them that they need to operate this establishment perfectly, with no violations, with any other problems whatsoever. They need to be responsive to their inspector. They need to be responsive to the police force who's been patrolling this area. And I received very favorable answers from the entire group of individuals who are seated in front of you, from the owners of the restaurant to Gabe, the security officer, or the security head who was actually at the scene the night that this incident happened. And I would like to be heard a little bit on the mitigation aspect of, they had an unfortunate incident inside the bar that evening, which I know is not part of the allegations. Your inspector dutifully left that out, which I think is appropriate, but they had a situation where Gabe had to detain an individual who was arrested for assault, for breaking a bottle over somebody's face in the restaurant that evening, okay? So there was kind of a lot going on in the situation overall in the restaurant that evening, and perhaps they should have made a different choice had the DJ stopped playing, whatever. They understand that the peril that they're in and the risks that they're running in operating this establishment going forward, both with service of alcoholic beverages to underage people. They've listened dutifully to the 3 prior cases on underage service. I have explained to them the need to keep their kitchen open, the need to provide food with all the drinks that they're serving because they have a restaurant license, and they all understand the criteria that they need to follow going forward. And so as I said at the outset, I had some nervousness about bringing this case before the board because typically I would like to have a more detailed presentation. I would like to have written policies in place. I would like to have all of the staff appropriately trained up on how to stop dancing when they see it happening. And that's something that the management is making a commitment to do. This evening in question on August 26th, they were slightly short-staffed for what they were expecting that evening. They had a good crowd. They had approximately 50 plus people who were remaining at the establishment at 1 in the morning. They're trying to have last call happen around 1:20 a.m. They're open until 2 o'clock on only Friday and Saturday nights. They close the restaurant at 10 p.m. On the other nights, and they're closed on Mondays, all day Mondays. If any of this documentation that I'm reciting needs to go into the board's file, I'm more than happy to supply the board with any supplements or appropriate information. As I said, we had a short time to prepare tonight's case in mitigation and to look at the charges and the allegations. At its core, I'm not sure that the board's inspector or the board has a clear definition of dancing. If we have people who stand up near their table, and I think that I heard this from my clients, that there is some discussion, and it was questioning during these warnings, the prior warnings that you heard testimony about what constitutes dancing, okay? They had an understanding that perhaps dancing needed to happen on a formalized dance floor in a particular area. It's easy to tell what dancing is. It's, for example, at a wedding reception where there's a parquet floor and there's a DJ inviting people up to join the dance. That doesn't happen at this establishment. It's not going to happen going forward. It didn't happen the night in question either. What we had was a situation where a gentleman perhaps was over intoxicated, removed his shirt, drew attention to himself. He was the guy that the inspector took the photos of right away when he walked in the door. And we also had a situation where there was a police scene and police were arriving to arrest an individual, a patron of the restaurant. It was a night that they do not want to repeat. I can say that truthfully, and they're going to put into place all the appropriate steps in order to make sure that they do not have to appear in front of the board again, that they're compliant with all of the board's rules and regulations, which I have reinforced in my discussions. And we've talked a lot about the operations and the various details of the operation that they need to be sorted out. They do have a security chief. They are thinking about bringing on off-duty police officers for security in the parking lot on Friday and Saturday nights. They're in progress of trying to find an appropriate candidate and obtain appropriate contracts for having that happen. And my recommendation to them is that they do that if they're going to continue with DJs and live entertainment on Friday and Saturday evenings. Those are the only nights that they use their entertainment privileges before the board. We also discussed the possibility of maybe switching entertainment to karaoke, which I think is certainly something that could be fun for the patrons and a draw that doesn't have the same sort of risk of dancing or customers thinking that they're going to be dancing along with karaoke. I've also indicated that they need to clearly post signage both behind the bar and at the entry of the restaurant that there is no dancing. If they want to revisit the dancing possibility, they need to come back to this board with a plan, business plan, and a floor plan that describes exactly how dancing is going to happen, the number of patrons they expect to be allowed to dance, and a security plan for how to control it. That's the case in mitigation, Mr. Chairman, Commissioner Snoops. I'm happy to have any of the licensees or managers who are here tonight answer any further questions for you. As I said, we're here hat in hand on the violation for the licensee not attending. They understand that the board is liberal with granting leave not to attend, but you have to request it ahead of time, and they acknowledge that they did not do that. Other than that, I don't know, and I did not have great amount of time to investigate any prior violations. I don't believe that there are any prior dancing violations that they've been convicted of, notwithstanding the warnings that you heard about, which my clients do acknowledge. The inspector and the chief inspector did try to make the board's regulations as to dancing clear. Thank you.
Thank you, Mr. Lyman. And I would just also like to say, if they do want to continue forward with dancing pursuant to 11.1102 of the Alcoholic Beverages and Cannabis article now, they would need to come back and request a dancing permit. Sounds a little bit like Footloose, but it's really for all legal forms of entertainment. So, it's just something that they would have to do along with that proposal, just so that the record's clear there.
Thank you, Mr. Pirelli. Appreciate that. We discussed that possibility in our conferences.
All right, great. Thanks, Mr. Lyman. Mr. Chairman, do you have any questions based on that mitigation?
If I may, I'd like to take just a second to review a couple things. There was several warnings given by both inspectors and other personnel at one time or another, whether it be administrative, about dancing at that location. The one photo that I'm looking at, I have a question about. These two gentlemen that are dancing, one that doesn't have his shirt on, the other one does. They appear to be in motion, if you will. But I also noticed there was probably at least somewhere in the area of 10 to 12 people standing in the background. And that also goes for another photo, which shows another 6 or 8 people standing in the background. The fact that they're standing and not seated, not eating, not enjoying a meal, raises some question as to what their ulterior motives were. Were they getting ready to engage in dancing? Were they just, moving around? But clearly, there's quite a few people standing and not seated. And your license is a restaurant license. And with that being said, I guess the question is, if the tables are moved and there's a lot of people standing around, what do you think the assumption would be for anybody under normal circumstances? And wouldn't it have been advantageous for you, the managers especially, to see that the tables were put back in a position that would reduce the floor or the dance floor, if you want to call it that, or the possibility of a dance floor? But I guess my question is more for the managers or Mr. Serrano, perhaps, Mr. Hicks. Why were there so many people standing? And is this the norm there? Is this what you usually see Wednesday night, Thursday night, Friday night, Saturday night, or are they seated for a meal?
Mr. Harris, I don't normally object, but that was a very compound question.
It was.
Do you want to rephrase it really quickly?
Furthermore, I would mention, and I didn't mention in mitigation, that there is a fairly large bar in this restaurant, and that it's common for people, especially late in the evenings, to be standing around in a bar, and that may be some sort of explanation for why there may be people standing. And I didn't think we were here on a charge of intent to dance. I thought we were here on a charge of dancing, which we did hear testimony about from the inspector. With that, I'm happy to turn it over to my clients. They can speculate, I guess, if you think that's appropriate testimony about what people think.
I'll tell you what, Mr. Lyman, let's disregard the question. I think I already know what I think is the answer to that question, so I'm willing to leave it at that. I just wanted to give them an opportunity if they had some explanation for it.
Chairman Harris, I certainly understand that. This is a teaching moment. If the record was going to be about the answer to that question, rather than that being sort of discussion about a motion or a vote, I will certainly debrief with my clients and explain the circumstances and what they need to know from your question.
Okay, no, I'm going to go ahead and withdraw the question then. Okay? I'm sorry. We do have the video. Yeah. Mr. Lyman, we have, and I don't know if you've had an opportunity to see it or not, but. Oh, okay. So you have had an opportunity to see the video?
I looked at the video, but the video looks to me like it's from February 2023, which is months in advance of this alleged violation. So if we're here about that as a different violation, I think it's objectionable. I think it's inappropriate for the board to review it as part of this consideration. We've acknowledged the warnings. Ostensibly, the warnings came because there was prior observation of dancing at the premises. So if we're here on multiple violations, tell me about the other violations, but I don't think it's appropriate for the board to consider video from February when a violation is alleged in August.
Okay,
You do what you're going to do. You're the chairman of the board, but that's my objection. Thank you.
thank you. And I will take it into consideration. No further questions.
Commissioner Snoops, any questions?
I guess my concern is your restaurant license and you're open till 2 a.m. How late's the kitchen open?
Can I speak on that?
We keep it open. So that night I was cooking back and forward, for example, and so I keep everything on. They order appetizers. I have tickets that can prove you 1:30 making meals.
Okay.
So if you're hungry, we're more than welcome.
Okay.
Any additional questions from the board?
None from me.
Mr. Lyman, anything further?
I just want to make it clear, they don't stay open till 2. It's at 1:30, we have everybody come out and step outside.
That's the policy, is to empty the restaurant at 1:30. I'm hedging by saying 2 o'clock because if there's anybody left at 1:30, we don't need to get in a situation where that was supposed to be what the restriction or an agreed patrons out time was for this license. The only thing I would mention is that, as I said, I've not reviewed the violation history. If there are any other violations for patron conduct, I'm unaware of them during this term of the license. These licensees have been on the license since 2021, and I do believe this may be their first time in front of the board having to answer questions about a violation of the board's rules and regulations.
Okay. Thank you, Mr. Lyman. Mr. Chairman.
I'm a little torn between what I see and what I'm hearing. And I have had personal opportunities to speak to Mr. Serrano, who I knew previously in reference to his business and the business going on. What I think I need to do here is to, in reference to the violations on illegal conduct, which would be dancing, I believe that I've seen enough to rule in the fact that there was a form of dancing being participated, and I also believe it's occurred more than once. The cooperation, I believe, Mr. Lyman, you said you were pleading guilty to that on the cooperation failure to appear?
Mr. Serrano was not here at the last hearing. That's on the last record. You adopted the minutes. I don't think I have a legitimate defense to say he was here somehow.
Okay, thank you. What I'm going to do is make a motion that on the second count, which is the cooperation, is find them guilty with a $100 fine. That was for failure to appear, Mr. Serrano, just so you know. And in reference to the first violation, the illegal conduct, I'm going to find them guilty as well, because I believe that I've seen enough to believe that there was dancing of some form of going on, and I'm going to make a motion that we fine them $400 for that, which is a total of $500 between the two, plus any administrative costs that we have accumulated. Looking for a second.
I second the motion.
Okay, all those in favor?
Aye.
Aye. Okay, Mr. Lyman, there you go.
Thank you, Mr. Chairman. Thank you, Mr. Pirelli.
Thank you, gentlemen.
Thank you, Commissioner Snoops.
Thank you.
Take care. You want to take a 5 minutes?
Okay, calling the next case. The Point Crab House and Grill, Ferry Point Restaurant LLC. Robert Jones III, authorized member. Julia Jones, authorized member. Chief Inspector Jim. Thank you, Mr. Katz.
Welcome back, Mr. Katz.
Everybody planning on testifying, if you could please stand and raise your right hand. Do you solemnly declare to affirm the guilty of perjury, the about to give the truth, all the truth, and nothing but the truth?
I do.
Thank you. Please state your name and address for the record, please.
Chief Inspector Jim Ford, Anne Arundel County Liquor Board.
Deputy Chief Inspector Sean Ralston, Anne Arundel County Liquor Board.
David Katz, counsel on behalf of, what is our formal name, actually? On behalf of the respondent.
Julia Jones, owner and licensee of Ferry Point LLC Restaurant, Stuart Jones. My address, 300 Kingsbury Drive, Annapolis, 21409.
I am Robert Jones, licensee, Ferry Point Restaurant LLC and Stuart Jones. Address is 682 Fairview Avenue, Annapolis, Maryland, 21403.
Thank you.
Mr. Pickett, if you could put your name and address on the record too, please.
Evan Pickett, 203 Benfield Road, Springer Park, Maryland, 21146.
All right, great, thanks. Chief Inspector Ford, do you want to give your statement of facts first, and then we'll turn it over to Inspector Ralston, then we'll go to questioning.
Will do. So this is an activity date of July 27th, 2023 for the Point Crab House located at 700 Mill Creek Road, Arnold, Maryland, 21012. This was in connection with a complaint investigation. Responding to the complaint received through the LQ Info email address on July 26, 2023 regarding alleged violations of the establishment's restrictions on its liquor license. This inspector visited the establishment at 5:48 p.m. on the date noted above. I was seated at a table near the bar where I could clearly observe activity at the bar, as well as the performing musician. I ordered food and a soft drink and began my observations. Observation 1, I observed bartenders serving patrons at the bar alcohol without the accompaniment of food. Number 2, musician playing a guitar and singing with amplification. During the time of my observations, Deputy Chief Inspector Sean Ralston and Inspector Mary Deschamps arrived to perform an overall inspection and for training of Inspector Deschamps. Both were instructed to not acknowledge my presence. Concluding my observations, I finished my meal, paid, and left the premises at 6:49 p.m., and that concludes the report.
All right. Mr. Katz or Mr. Pickett, we'll take these one at a time. Do you have any questions of Chief Inspector Ford?
Well, I do have a sort of a preliminary matter to raise, and it's based on a conversation I had earlier with Inspector Ford, so I wasn't quite sure as to how we would proceed this evening. You know, I believe that there is ambiguity as to, let me not speak for you, Inspector Ford, but there's ambiguity in terms of the current restriction and sort of the content related to this violation. So I wanted to have an open discussion, if that's permissible, on, and Inspector Ford, we discussed this today, on proposing clarification on this restriction, and if the license holder and the board are agreeable to this clarification, and perhaps changing the language on this restriction, perhaps a withdrawal by the board of this violation.
So I think at this point we're kind of into adjudicating these violations. You know, we're here for 2 cases on the point tonight. We've got your violation now, and then we're going to get to the restriction aspect of it. So at this point, we're just going to continue forward procedurally with the adjudication of the violation. Ultimately, you can make an argument in mitigation as to whether there's ambiguity on the restriction and whether the board should, or how the board should take that into consideration. And then with respect to altering or modifying the restriction and adding additional clarity or whatever language you support, we can take that at the next one. I just want to make sure that we have a clear record on both of these just for appeal purposes. So, you know, at this point, if you have questions for Inspector Ford, you can certainly ask him questions. And then, you know, we'll turn it over to the board for questions from Mr. Ford. Same thing with Mr. Ralston. So if you have any questions for Chief Inspector Ford for the violation, you know, that's kind of where we are procedurally.
Okay, that's fine. Inspector Ford, in this particular evening, you noted that you observed other patrons at the bar consuming alcohol or drinking without food.
Correct.
You would agree that nothing precluded these patrons from ordering food at the time?
Correct.
and you didn't have any knowledge of whether or not food might be on the way. Just at that moment, that point in time, you did not see food in front of them.
That's correct.
Okay. And how many patrons did you say you saw at that time?
Oh, it was at least a dozen.
Okay. You said you ordered food, and that would have been provided or was provided to you at the bar at the time.
I was not seated at the bar. I was seated at a table near the bar.
Seated at the table near the bar. I assume you saw other patrons at the bar consuming food.
I did, yeah.
Okay. And for clarifying purposes, when you ordered from the bartender, you said you ordered food and a drink simultaneously?
I ordered from a waitress.
For the waitress, I'm sorry. You're at a table close by.
Yeah.
The waitress, did she ask you what you wanted to drink first?
Yes.
Okay. Was a drink brought to you first?
Yes.
Okay. And then you subsequently ordered food?
I did.
Okay. Would you agree that that's sort of the normal course in any restaurant?
Yes.
Okay. I have nothing further.
All right, thank you. Mr. Chairman, any questions just based on Chief Inspector Ford's statement of facts?
No, I have no questions based on your report, or Chief's report.
Commissioner Snoops?
No questions.
All right. I'm assuming no follow-up since there were no additional questions at this point?
No.
All right. I'm going to turn it over to Inspector Ralston, who's going to provide us a statement of the facts, and we'll kind of go through the same procedure.
This report's dated August 27th. On the above date, at approximately 6 p.m., this inspector stopped by Point Crab House and Grill for surveillance of operations within the bar and dining area. Over the course of approximately 1 hour, this inspector observed the service of alcohol to approximately 30 or more people in the bar area without such service being in conjunction with the meal.
Okay. Mr. Katz, any questions based on that statement of facts?
I do. Inspector Ralston, you say you observed 30 patrons receive alcoholic beverage without the conjunction of a meal.
Approximately 30.
Okay, approximately 30. Do you mean simultaneously with the meal?
30 people at the bar drinking without food.
Okay, but you would agree that you didn't hear each and every order that was made by each one of these patrons?
Correct.
Okay, so you don't know whether they ordered food later on or in fact, perhaps they ate beforehand, but, I'm saying before you made that observation, that's possible, correct?
Correct.
Okay. Do you interpret in conjunction with meaning simultaneous?
I don't think that's for me to define.
Well, I think it is, right? Because you're citing the violation because it's not in conjunction with. I'm trying to understand what your interpretation of in conjunction with is.
In the course of the meal, of sitting at the bar during that duration.
So each of these patrons that you observed, did you observe from the moment they entered the restaurant?
Negative.
To you didn't?
Negative. Only during the time I was there.
Only during the time I was there. Okay. So you didn't see from the beginning, and you didn't see them actually pay the tab at the end.
Correct.
Okay. I have no further questions for.
Thank you, Mr. Katz. Mr. Chairman, any questions?
No, I'm sitting here. The 30 people that Deputy Chief Ralston, the 30 people or so approximately that you saw, what was the time period that engulfed? Was it half hour, an hour?
Over the course of the hour.
Okay. Did you see anybody delivered food out of those 30 at all, or?
I would say over that course of that time, there was about 5 people.
Okay.
A couple people ate, a couple people got food to go.
Okay.
About 5.
Well, that's good to know that it wasn't all 30.
Correct.
Okay, very good. Thank you for clarifying that. While you were there, did you observe anybody order more than one drink of alcohol, do you think? In other words, were there multiple drinks delivered to any of those 30 that you could see or you were aware of?
I didn't have full view of the bar the whole time because I was at a table.
Understood.
And most people were only up to the bar, but there was a group of like 5 or 6 people that were too deep ordering multiple drinks during that time.
Okay, thank you. No further questions.
Commissioner Snoops? Mr. Katz, any follow-up
I do have a couple
questions?
follow-up. Inspector Austin, are you familiar with sort of the seating process at the point?
Roughly, as I sat there.
So you know that the restaurant doesn't take reservations?
No, I do not.
Okay. You would agree that it's not uncommon for a restaurant that doesn't accept reservations, that sort of is first come, first serve, that the meal experience, the culinary experience, typically starts with a drink?
For some, yes.
Okay. Was it busy in the restaurant that evening?
Very.
Very busy. Do you agree that it's effectively a natural progression in a busy restaurant to start at the bar with a drink and perhaps move on to the meal when seated?
For some places, yes.
Okay. Are you familiar with that happening at the point?
I have not been there that often.
Okay. Nothing further, Mr. Ross.
Any follow-up questions?
No follow-up.
Commissioner Snoops, any follow-up questions? Okay. I don't think we have any further testimony from the board at this point, so we will turn it over to you, Mr. Katz. You can present your case by way of proffer or testimony or a combination of both. This will just be for questioning purposes if you have witnesses. If not, we can see if the board has questions and then turn it over to you in mitigation. But we'll turn it over to you for the board right now.
You know, I think the majority of our evidence is to be submitted via proffer.
Okay.
But we certainly deny that this is a violation. The restriction on the license reads, all alcoholic beverages must be served with the conjunction of a meal. You know, respectfully, I think from a grammatical standpoint, it's unclear what that means. And I think that from a practical standpoint, the intent of this restriction can't be that every patron must simultaneously take a bite of food in advance of ever having a drink. And I think that is the issue before us. And I believe that the intent of the restriction, when it was implemented in the license back in 2010, was not such that before you can have a sip of alcohol, you must eat a bite of food first. And I apologize because I sort of want to give the historical context of what I believe the historical context to this original restriction, what led to this original restriction, and sort of what has transpired since that time. The restaurant that existed prior to this, Magathy Seafood, was, not really a restaurant. It was a waterfront bar that served limited bar food and bagged crabs to go. And this location is in a high residential area, and the transfer of the license, at the time, the new issuance of the license at the time in 2010 brought a lot of opposition by the neighborhood. And understandably, the concern was that the neighborhood did not want the point to be a rowdy sports bar. And what I can say is, since that time, it has sort of been the opposite of that. The Point is an award-winning restaurant. I mean, it is. I can go through the list of awards, but every single year it has been awarded either via the Capital Gazette, the Baltimore Sun, or the Severna Park Voice for its culinary experience, its ranging seasonal menu, its culinary atmosphere. It's a high-end restaurant, and that is reflective in the fact that sales consistently have ranged from the high 60s to the low 70% sales of food to alcohol. It's the furthest thing from a rowdy bar. It's a very busy, crowded bar because the demand for the culinary experience in this location is extremely high. But we don't believe that the intent of the restriction was such that the consumption of alcohol had to occur simultaneous with the consumption of food. It goes against sort of every restaurant principle, you know, being in the hospitality business. You don't want to have an atmosphere where you are demanding of your patrons that they immediately order food and that they can't be served they can't be served an alcoholic beverage without first receiving a meal. I mean, from outward, and set aside explaining the fact that there's a restriction on the license, arguably that speaks to that. It's an impossible thing to adhere to, and it's an impossible thing to police. Standard operating procedure in any restaurant is, what would you like to drink first? And the expectation that we will not bring you out a drink before that is unreasonable and impractical and couldn't have been the intent of the restriction. I can list a variety of different instances where an applicant, if you are interpreting it this narrow, that it's an impossible thing to adhere to. I've been in the third wheel on many dates. Sure, friends meet other friends out. I'll meet you there. I know you're dining there. I'll come stop by and have a drink and say, hey. Is it the expectation then, during the course of my friend's meal, that I also have to have a meal? What if I'm joining in on their bill and they're paying for my drink? What if I'm young, I'm 19 years old, they can't afford, I'm sorry, 19. 21. Sorry. I'm 21, and my friends can't afford to pick up my drink, so I pay for myself. They've had a meal, but me independently, I stop by, have a couple of bites of their appetizer, and pay for my own drink. Is that a violation? What if I have a medical emergency halfway into my drink? What if I have a family emergency halfway into my drink? You know, if you look at the definition of what in conjunction with means, and this is defined by Law Insider, it means an event held during the same time period and in the same general locale as part of a schedule of activities and open to all persons attending. It does not mean, it does not contemplate a chronological order in which things happen. It's part of an entire experience. And at some point, both have to be offered. This morning we listened to the transcripts of the original hearing from 2010, when arguably the restriction was consented to. And I'll go into why perhaps the way it is being interpreted now was not what was consented to. But in that hearing, the chairman regarded the restriction that alcohol would include service of a meal, right? And if you look at the definition of service, it's the action of helping or doing work for someone. In my mind, is the intent of the offering. The intent of the restriction is, we don't want you to be a rowdy bar. Therefore, you always have to offer food. But you can't force feed people. And it can't be interpreted as a restriction that force feeds. It has to be an interpretation that the entire restaurant has to orchestrate as a restaurant and has to drive a culinary experience. And that's exactly what it does. By every seat in the house, whether it's the outdoor seating, whether it's the bar, whether it's the high tops, whether it's the dining room, offers food. And it offers a high-end experience, and it is an ever-changing menu of food. It is the furthest thing from a rowdy bar. Now, at the time the restriction was implemented, it was a Class H license. It was 2 hots a day. It's my understanding that the board at the time wanted to see sales reports, right? But at the time the restriction was implemented, the state had not passed a referendum requiring this 51% threshold that it requires now. I believe the intent at the time of the restriction is to be 51%. And had the point submitted sales reports that showed that sales were less than 51%, at that point they could have violated because it wasn't in conjunction with. That never happened because sales had never dipped below that threshold. Once the state in 2016, and I believe it was further updated in 2020, required the 51% threshold, it sort of solved the problem for the restriction, if you will. Now the state required 51% proof, something that didn't exist at the time the restriction was implemented on the license. So really the argument is two-part. We don't believe that the intent of the restriction was for simultaneous, at that exact point of the sale, that you have to take that bite of food first before you can have a sip of alcohol. And I think from the inspector's testimony, they really couldn't make that distinction of, let me rephrase that. I think they're saying at that moment they viewed there was no food, but they cannot confirm when the sale, when the service was initiated, and they could not confirm when the sale ended. So from my perspective, because of that, there is no violation because it doesn't require simultaneous action. It just requires in conjunction at some point in time. There has to be an offering. Secondly, I'd say that if the restriction is interpreted in this strict sense, I don't believe the restriction is permitted by law because I believe it goes outside the boundaries in which this board can restrict a license. Now, I'm not disputing the fact that restrictions like this can be consented to, and there's evidence to suggest from Mr. Delavan that it was consented to. But I think if you look at the cases and you look at instances where the courts have upheld restrictions because of consent, it was based off of meeting with communities in advance, written agreements. This restriction was entered into, from my perspective, under some duress. There was an evening of opposition. And a restriction hadn't been brought up or suggested until Don Wood from I believe it's the Manhattan Beach Community Association made that suggestion. And yes, again, I can't speak for Mr. Delavan, who, I feel like everybody holds him in incredibly high respect, which I do as well. But throughout the course of that evening, and in the final issuance of the license, yes, he does make mention that the applicant agrees to the restriction. But I go back to, I believe the intent was not that it happened simultaneous. That could never have been the intent because it's an impossible thing to police. One last thing I'll say is, and again, just a piece of evidence of why it's impossible. Let me go back a sec. As part of that application, the point was really, the restaurant that we know today was really expanding. It was limited bar food originally under Magathy Seafood. As part of that new issuance of the license, they expanded the kitchen so that the culinary experience could be enhanced and better. And it truly was a restaurant, not a smaller kitchen that served limited food. I had one other thought I wanted to add. Bear with me one sec. Okay, my client and I have spoken about this, and they do want to note, really the restriction that was, the basis for the restriction was really because you had bad operators to begin with beforehand with Magazine Seafood. And really, from the time my client have operated the restaurant, it has been, an extremely popular destination restaurant for the county. They have not been bad operators. Now, I was joking about this with Inspector Ford this morning, or today. Anne Arundel County, for better or for worse, is a not in my backyard county. It's a county that attracts folks to come out and complain. But I would say with every complaint, we have 1,000+ people writing in support of what a great experience it is. And they're talking about not that it's an awesome bar, that it's a fabulous award-winning restaurant. So I would conclude with, we deny that there's a violation because the intent of the restriction isn't to require the simultaneous ordering of food and alcohol. And what was observed by the inspectors does not negate the fact that food is and is always offered at each seat, outside, bar, otherwise, and that there's no evidence to suggest that these patrons didn't eat at some point and couldn't have eaten at some point. And I would conclude with that.
Thank you, Mr. Katz. Mr. Chairman, do you have questions?
I have a couple, I guess. The simultaneous, or your interpretation of the simultaneous. The deputy chief sat there for 45 minutes or so, watched 30 people. He admitted that some did receive food during that time, but not all. And I don't believe it was, and this is my interpretation of what the board, and by the way, I was around back then. Yeah. I don't believe it was the intent of the board to demand simultaneous service. I really don't. I think that's a stretch at best. And I guess my question would be to you, knowing that there was a time period where 30 were observed and then it was reduced to, 7 didn't receive food and 5 later, were observed receiving food. That still leaves some that were served without any connection or conjunction with any kind of food service. I think the way the restriction is written, all alcoholic beverages must be served in conjunction with the meal. It doesn't say simultaneous. And I believe the intent at that time of my peers and supervisors and board was that they wanted to make sure that this was not going to be a bar or a tavern, that it was going to be a restaurant, which you became. And by the way, super fantastic. I love your place. But I think the whole point of where I'm going with this, and I'll try to put it in the form of a question for you, is I'm not so sure, and I guess my question would be to your licensees, what was their interpretation of what this restriction said? So.
And I will yield to the Joneses, but let me just start. I think their interpretation was that this had to be a restaurant, and it's a restaurant that had to, whose sales had to, the majority of its sales had to be food, because at the time there wasn't a 51% test, and I think that's exactly what they've done. In fact, they've gone above and beyond regularly with that of that 51% threshold. And I think that it goes to, sort of the practical side of operating a restaurant. I will say that, having painfully done this, wait times at the point are regularly 2+ hours.
Yeah.
So it is not uncommon for someone to sit at the bar and wait for a table for an extended period of time. It's a fabulous experience for the patrons. And what I think is important, and this was always understood, and perhaps how the restrictions should be clarified, but there is no area, and this is, and by the way, I would say this is not a requirement of a Class H license, but there's no area in the Point Restaurant where food is prohibited. It's offered everywhere. So if I come in and I get my buzzer and I got to wait 2 hours and I'm sitting in their outdoor area, I can order appetizers. If I'm going to the bar and I find a seat at the bar, they'll literally put down crab paper and I can pick 12 crabs at the bar. So there is no limitation. No area of the Point is targeted for, we just want you to drink here. It is entirely open to eating. So I think that was my client's interpretation. That's how they've acted, and that's why their sales reflect that. You know? And I would say that the menu is farm to table. It's ever-changing. It's variety of specials. And it's award-winning. You know, sure, alcohol sales matter, but it is focused on the culinary expertise of its owners. You know, they want to be an award-winning restaurant. They wanted to turn it into an award-winning restaurant. They've done that with a few places in the county, and that's exactly what they did. So I would say that what's common is nobody calls and tells you what a great job you're doing. Nobody puts a letter in the file for how much they love something. You know, but if you actually did that here, the numbers would far outweigh the complaints. So, Julie, do you have anything to add to that?
Well, to kind of respond to your direct question about
Please,
the
yeah.
30 or so people that, weren't observed drinking or weren't observed with food, I know they were waiting for a table. You know, we are busy from June to August. We do about 50% of our revenue in 3 months. So that's our make or break period. And it's busier than we ever thought it was going to be. You know, we focused on what we focused on. 2 deep, 3 deep, those are bar terms. We're not a bar. But people, while they're waiting, I don't know why they wait. I really don't know why they wait 2 hours, but they do. And they got food. They waited while they waited for a seat. You know, that's what they were doing up there. And to, Dave's right. You know, for 11 years, prior to the state laws changed with the 51 to 49, we were asked by the board to provide sales reports every once in a while, and we did. And it was always 70-30 and that's our average.
I think it said in the emails, to determine compliance with your license, we need to make sure that your food sales outweigh your alcohol sales.
So to
we
answer
would
that
provide
question,
them.
to answer your question,
That's
to
how
our
we thought
understanding, that
it
was
was interpreted.
so we believed we were in compliance with that restriction until August.
Can I add, Mr. Chairman? You know, again, I mentioned the awards before, but let me just rattle off really quick. 2013, What's Up Media, Best Kept Streaker, Best Chef. 2014, Best Chef, Capital Gazette. 2015, Best Business Lunch. 2016, Best Waterfront Restaurant, What's Up Media. 2017, and this is like every year from 2017, Best Maryland Crab Soup, Best Atmosphere. There's not a single award for Best Bar, Best Club. You know, this is all restaurant driven. So, I don't think how it can be interpreted any other way other than you need to be a restaurant. You need to predominantly sell food. And Bobby probably kicked me under the table for saying this, but landlords judge, rent, and value of real estate based on sales, and the restaurant performs very well, and is probably one of the top grossing restaurants in the county.
And another thing I would say too, in terms of like how we interpreted it and observations of people maybe at the bar, there have certainly been times when people have gotten on the wait that's 2.5 hours. They go to the bar, they have a couple of drinks, and they're like, you know what? We can't wait any longer. We're going to leave. We can't police and say, you can't leave because you haven't eaten food. Like, we need you to eat. Like, and that's just one instance of a million situations that might pop up. that might make it really, really hard to, and I think too, the difference here is simultaneously and in conjunction with, it is offered, it is available. There's never been a moment where we've wanted to be bar owners at all. We wanted to create an upstanding business in the community that we live in where we can take our children, employ our children, now take our grandchildren. We do not want to be a bar where people are getting drunk and rowdy.
We've been through the ringer, 36 years I've been in this business, from the back of the house, washing dishes, waiting tables, tending bar. Those 2 a.m. nights, we have nothing, we close at 10 o'clock. We're a family restaurant. We understand the spirit of the restriction. We understood that we were in compliance for a decade. So this is kind of a surprise to us. We didn't know we were doing anything wrong, honestly. And if we did, we apologize. And maybe we just need to clarify things.
And we also kind of understood we weren't the original licensees, but we were here for, all of the hearings and everything. And we understood that some of these restrictions were a little bit unorthodox. But at that point, we needed to get open, and we, it was the other licensees and the attorney that agreed to it, and we were on board with that. But we also had faith that maybe after a decade of running a really respectable restaurant and not a bar, that these kinds of things could be taken into consideration for us.
Any other questions, Mr. Chairman?
I do, and this may come up again later on, I don't know. But within the last couple of months, there's been social media out there that has come from the pier. Excuse me, the point. It made the board sound like and look like we were literally making up rules and regulations and putting you under restraint.
And let me, I'm sorry.
Not our intent.
I would like to speak to that. If I may, as long as you're finished, Mr. Chairman. I'll apologize, because, and I will fall on my sword for that one in the sense that we, I have found throughout my career, mainly in land use, now in some liquor board hearings, but, opposition and that loud minority, if you will, does carry a lot of weight. And what we wanted to highlight is the fact that there is a significant amount of support for the point, despite the local opposition. So a social media campaign evidencing that we thought was beneficiary because we wanted to show the support. Now, with that said, the verbiage, and I think lines got crossed in in our communication on how that should be phrased. My clients are lay people. They're not lawyers. From their perspective, and I think you could say not how this board was treating them, but from their perspective, they had historically provided sales reports. And in their eyes, that's what evidenced that they were more a restaurant than a bar. And, that has changed. At the time that the license was issued, that 51% threshold by the state didn't exist. And then,
go ahead.
Unless I'm saying something wrong, it's ours. Okay. That 51% threshold, the H at that time was 2 hot meals without a percentage qualifier in the annotated code in 2011. That was adopted via referendum in 2016 and further amended in 2020. So we view that at least perhaps how the board was interpreting the restriction has changed, might have changed. So that is where that verbiage came from, and I will apologize profusely if it came off as that there was any finger pointing. It was really directed to, we want to demonstrate how much support there is for the restaurant, because we knew that the vocal minority out there would always be vocal. And I would say that after conversations with Inspector Ford, certainly not the intent to offend the board in any way or paint the board in any inappropriate or incorrect light, we advised them to take the post down and haven't continued with anything.
Yeah. and you were actually asked to take it down before you took it down several times. And then finally, I believe you agreed that you would take some action, and it was taken down. And I appreciate it being taken down. Nobody wants to be shown as a villain or a culprit, especially when it's not justified. And none of those comments were justified. None of them. And I'd be more than happy to sit down with you and go over and tell you how we can prove that they weren't justified. But the point that I'm getting at now is the fact that that type of propaganda or that type of maneuvering, that doesn't help the situation any. It makes it worse, I think, my opinion. But I understand what starts off as maybe one Facebook, ends up spreading like wildfire. And I can tell you, I got a lot of calls. So you or whoever accomplished what they wanted to one extent. Not that it was necessarily a good thing. And I want to make that clear, not just to you, but to anybody that's listening. And we've had another establishment that tried or did something very similar, and it backfired on them. So if we're wrong, we'll be hopefully the first to step up and say we're wrong. But getting back to the point here, when it comes to this particular violation, you've answered my question, I think, in the best way you could do that. So I'm going to rest with the questions and see if you have
Commissioner
anything.
Stoops, do you have any questions?
No, I don't.
All right, well, Mr. Katz, unless you have something new to add, I think we're going to turn it over to the board for a decision, okay?
Nothing further.
All right, thanks.
In this particular violation case, number one, you were only charged with one violation. When I read the reports, I saw 4. Yeah. But it was the chief's decision and the inspector's decisions to charge you with one violation, which I give them credit. And I asked, I think the point was, well, if you also did this and you observed music that was not according to the music restriction, and there was, somebody there, excuse me, somebody there wasn't doing something else and was volleying a rock, why didn't you charge them with those two? And I believe the gist of the answer was, well, we're not out to pound them, but we do want to make sure they understand that they can't violate the restrictions. And I thought that was pretty admirable of the chief and the inspector. Because there was only one count, unlike everything else you've heard tonight where there was 2 counts and it ended up doubling the fines on almost everybody, I'm going to make a motion that Mr. Katz did a good job, but I'm going to make a motion that we find you in violation. And I'm also going to, in that motion, I'm going to suggest a $100 fine. That's, I think, the first time I've done that. But I'm going to suggest a $100 fine. But I think most importantly is we have another case coming up, and we'll discuss that in a lot more detail, I'm sure. But Mr. and Mrs. Jones, like I said, I've been to your place, and I really like what you've done there and all that. But in this particular case, I believe the inspector and the chief have made their case. So my motion is to find you guilty and just fine you $100 plus cost. Okay, I need a second.
I second.
Okay, with that being said, all in favor? Aye. Okay, so that ends this case. I'd like to ask for a 10-minute recess if we can.
Thank you.
Hopefully you can use that to your advantage too. All right.
Everyone, please do come back within 10 minutes. Appreciate it. 1 minute warning, please, everybody. All right, everybody, if you could please take a seat. It's official.
Okay, Mr. Maloney, Inspector Maloney, would you make sure everybody outside is aware that we're...
Okay, I'll be calling our next case, which is, we're moving forward with Captain Kids next. That's Knox LLC, Switi Patel, Managing Member, Inspector John B. Maloney. This is for a transfer. Currently, Swishan, President on behalf of MJC Inc., trading as Captain Kids at 5823 Deal Churchton Roads, Deal, Maryland 20751. This is a Class A beer, wine, liquor, wine tasting, and Sunday license. There is a restriction on the license dated as of 9/26/2000 that all employees involved in point-of-sale transactions must be alcohol awareness certified. I'm sorry, if you could stand, please, and raise your right hand. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes,
Thank you. You may be seated, and if you could state your name and address for the record.
my name is Switi K. Patel. My address is 304 Donwood Drive, Edgewater, MD 21037.
Thank you very much.
Good evening. My name's Chris Drummond, D-R-U-M-M-O-N-D. I'm an attorney in Centerville, Maryland, 119 Liars Row.
All right, thank you, Mr. Drummond. I appreciate it. You can go ahead and present your case at this point in time. You can question your witness, or you can present by way of proffer.
Well, we'll do a little bit of both. Ms. Patel is in an extended family of Patels who own a general store in Churchill, Maryland. That's how come I'm involved in this matter, which also has a liquor license, as well as the extended family has a license in this county. I would like to take a moment of personal privilege and thank your staff members here who were very helpful with me. I'm quite used to the procedures on the liquor boards on the Eastern Shore, not so much over here, and every county has its own peculiarities with respect to applications, and Anne Arundel County is no exception. And your staff members are very helpful with me to complete the application so it could be presented to you. We have now, this matter's been postponed a couple of times, the transfer application, because of the ongoing negotiations between Ms. Patel and the current license holders and owners of the real estate, matters regarding the asset purchase agreement, the lease, and so on. That's now been finalized, and we hope to settle if the transfer is approved before the end of the year. Now, Ms. Patel, could you tell us, you've given us are you a citizen of the United States?
Yes.
Have you ever been convicted of a felony?
No.
In the United States or in India, for that matter? All right. Have you ever held an alcohol license in this county or any other county before?
No.
And that would include, you do not presently hold a license, I think I said this, in Anne Arundel County, such that you would hold 2 licenses at the same time, is that right? You would not hold 2 licenses at the same time?
No.
Are you the managing member of Nakesh LLC, N-A-K-S-H LLC?
Yes.
And are you the sole owner of that limited liability company?
Yes.
And you're asking that the license be transferred to you as a licensee for the benefit of Nakesh LLC, of which you are the sole owner, is that right?
Yes.
Now, have you read and studied the rules and regulations for licensees in Anne Arundel County published by this board.
Yes.
Is there anything about those rules and regulations that you do not understand? Is there anything about those rules that you don't understand? Or do you understand them all?
I understand.
Okay. Let me ask you this. Have you had occasion to work in the liquor stores that are managed and owned and licensed to various members of your family?
Yes.
And would that include the Road store in Churchill?
Yeah.
In,
And Westlake Liquor, Waldorf.
I'm sorry?
Westlake Liquor in Waldorf.
Can you hear her? There's a,
Yeah. I'm
store
having
in
a little
Waldorf,
problem.
Maryland. All right. And you've had occasion to work in those stores and become familiar with the operation of the liquor store?
Yes.
All right. Have you taken the TIPS training?
Yes.
All right, and her TIPS certificate is among the package that you have before you.
Mm-hmm.
What would your operating hours, normal operating hours at Captain Kids be if the license transfer is approved?
Monday through Saturday 9 a.m. to 11 p.m. and Sunday 9 a.m. to 10 p.m.
You understand that the actual length of time the store can be open is greater than that, but those are your planned hours of operation.
Yeah.
All right, how old do you have to be to serve alcohol? How old do you have to be to serve
21.
alcohol, to purchase alcohol?
21.
And what are the satisfactory proof of age that can be shown to authorize the sale of alcohol?
Valid state driving license.
Talk to them, not to me.
Valid state driver license, MBA ID.
Military ID?
Military ID and valid passport.
Passports, that's right. How long are you required to keep records of sales as a licensee?
21.
Pardon me? How long are you required to keep the records of your?
Oh, 2 years.
Okay. Now, if the if the board approves this transfer, you understand that as the licensee, you're holding it for the benefit of Nikesh LLC. That means you're on the hook. You're responsible. Do you understand that?
Yes, yes.
And just as you've seen tonight, if someone who's working in the store, for example, sells to someone under 21,
Yeah.
you're responsible.
Yes, I'm this.
Not the person who sold it, you, because you hold the license. Do you understand that?
Yes.
And you see what can happen if you violate the terms of the license. It could cost a lot of money,
Yeah.
or you can lose the license. You understand that?
Yes.
Will everyone who works at the Captain Kids, if the license transfer approved, also receive the alcohol awareness training?
Yes.
Are you familiar with the ID scanners that are part of the point of sale equipment?
Yes, we have in the store.
They're in the
ID
store in
scanners.
Churchill?
Yes.
And are you familiar with how to operate that ID scanner?
Yes.
And do you plan to have the ID scanner at Captain Kids if the license transfer is approved?
Yes.
That's all the questions I have.
Mr. Chairman, any questions?
Yes, I have a couple.
You need to keep your voice up. Keep your voice up, okay?
I'm sorry.
I just asked her to keep her voice up.
Okay, thank you. I was going to do that too. Excuse me. Mrs. Patel, and this may have been mentioned earlier by your attorney, but I'm asking you personally, do you possess any financial interest in any other liquor license within the state of Maryland?
No.
You have no financial interest at all in any other liquor establishment?
No.
Okay, thank you. All right, I guess I really don't have any other questions for anybody at this point, so I'm going to go ahead and
Mr.
pass.
Chairman, we're aware that there are some additional documents that we need to produce such that if the transfer application is approved, we know we can't pick it up until we produce a sales and use tax certificate and a few other things, which we're working on.
That does bring up another issue, if I may. I'll inject it in here. I believe our inspector in your area, your sector, mentioned the fact that you have a container for storage on your property.
Yes, we have one container in the back.
Captain Kids?
Yes.
Okay. You're talking about a cabin, is there a container there?
Yes.
Okay. Do you have a permit from the comptroller's office and a letter from us giving you permission for that? Are you aware of any?
No. Does the current license holder, are you asking? Because I don't know.
Nobody seems to know, but
I haven't, I think it's, no. I don't think the current license holder has a license to be storing alcohol in a container, if that's what you're asking. I don't think so.
okay, well, she's going to need one.
Yeah.
Or she's going to have to remove it all
Yeah.
and send the container out.
Yeah, that makes sense.
So, but I'll make that part of the motion at
Okay.
the end. But
No,
I just wanted to ask that question if I may.
Understood.
Okay, I'm finished.
Not sure that's a very safe place to keep it anyway, so.
Commissioner Stoops, do you have any questions? All right, Mr. Drummond, do you have anything you want to add?
No, I don't.
All right, Mr. Chairman.
Okay, with that said, I'm going to make a motion that we approve the transfer. And I am going to put in that motion that you proceed to check on the container on the property. And if you don't have a permit from comptroller's office and a letter from our office, which usually follows shortly thereafter, you need to get one. And
Yeah.
I'm going to give you 30 days to do that.
Okay.
And that should be ample time, but if you need more, just contact our office, okay?
Okay, thanks very much.
All right, and so the motion is to approve the transfer.
I second the motion.
All those in favor?
Aye.
Aye. Congratulations. Lots of luck.
Thank you all.
Thank you.
Good luck to you. All right, calling the next case, Tuscan Prime.
Say hello to your,
Yo, man, I will.
Thank you very much, Mr. Brown.
Thank you.
I regret to say I've known him for about 40 years. He regrets it because it wasn't long.
Please remain standing and raise your right hand. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. And if you wouldn't mind stating your name and address for the record?
Julianne Sullivan, 1504 Stacy Lane, Annapolis 21409.
Thank you.
Can we find out if she's representing someone? She's a opponent or a protestant or?
Opponent.
Okay, I haven't seen you. Did you sign in on this hearing sheet?
No, I forgot to, but I came up during the break and asked if I could just
Okay.
We'll get you to do it now.
Sorry.
Yes. Now state your name and address.
Michelle DeMayo, 211 Norwood Road, Annapolis, Maryland, 21401.
Thank you.
Uh-huh.
All right, Mr. Brown, we will turn it over to you. You can present your client's case by way of proffer testimony or a combination of both. After you've proceeded to present your client's case, we'll have the board ask questions, then we'll hear from the opponent. You'll have the opportunity to ask questions there.
Thank you.
Yep.
Thank you. Members of the board, I address your attention to the letter July 12, 2023, which is an extremely well-written letter written by Brian Lyman, not me. Okay, so if you need any information on this license, Mr. Lyman, who's sitting in the second row, ready to take credit for all he can, has done a good job on this application. I present to you the applicant asking to change a Class H license to a Class B license. I present to you an applicant who has, in the 17 years she's been involved in the alcoholic beverage business, has been on 7 or 8 licenses and never had a violation in that 17-year period in the 7, 8 different places she's been, in-state and out of the state of Maryland. She's been involved. She was involved in restaurants in Florida and restaurants in Maryland, and she's been doing it for 17 years. In order to get to this point, we had to do a lot of things. We had to move some things around, and you're aware of the other licenses that we switched in order to make this happen today. She has the experience, she has the background. The reason for this license request is that they have been selling alcohol to go in their own wine labels, and you've got all the labels in there. She asked if she should bring wine for everybody tonight to see the labels and all that, and I held off on that even though I thought it might be good. At this late hour, you might enjoy it right now. But you can see that they have 3 different labels of wine. They're all Tuscan Prime labels. They have been operating there at Tuscan Prime. They got their license as an H originally, and you got the license, if you recall, during the COVID situation where, under COVID rules, they were allowed to sell wine to go. And that's all they're doing. It's only their wine, nobody else's wine, only their labeled wine, no other alcohol, nothing goes out the door except for what they have their label on. And it's been a success situation. They brought a lot of people in, and it's been very positive for them to do this. We filled out all the documentation. You have everything. You'll note that the property was posted. I believe your inspector probably showed the posting. It's been advertised as appropriate, and I'm not sure that there's anything else we need. Hopefully, because Mr. Lyman did this, not me, you have all the documents you need. You have all the corporate things. You have everything signed, and it wasn't easy to get here, but we're here right now, and we appreciate the board's assistance, because when we had questions, we would talk to your board counsel. We'd find out what we should do on all that, to the way to move it. And your board counsel has done a great job of helping almost every licensee out here that I know when it comes to getting applications in and completing them the right way and doing some things. So that's my simple presentation. You can ask Mr. Mayo any questions you want on anything on it. She's ready. My preparation for her tonight in order to be at this hearing was, I'll meet you there at 5:30, and you're just going to testify when we get ready. Okay, she knows the board better than I do. She said, we're not going to be out of there at 9 o'clock. I said, now you're at 7:30. So that's where we were. And where are we?
8:46.
Yeah, so we're close to 9 o'clock on that thing, so she was accurate. But that would be the presentation. I'd ask the board to take our whole application as an exhibit here, including we have the digital application for you all too. We have all the directions and the square footage on there. We have all the seats on there as necessary. We have all the information you need from the corporation. She is TIPS-TAM certified. She has everybody that works there is required to be on their part. They do it. They do have a bar. Unfortunately, we haven't been able to get dancing yet because we couldn't move the tables. But give us some time, because it's a really big place. So the situation here is that we're here for a Class B, an upgrade of the license to the B for purposes of sale of the wine, but they are the only ones that carry this wine. And that's the important aspect of it. So it's different than others. It's good for the community. It cannot adversely affect it. And you've seen them selling this wine for nearly up to 2 years, till it had to end in June of this year, without one violation on anything, without one complaint from anybody that I am aware of. That's my presentation.
All right. Thank you, Mr. Brown. Mr. Chairman, questions?
I do have a couple. Welcome back, Mr. Mayo.
Thank you.
First question I'm going to ask, and it's directed to you, not your attorney, and it's one you've heard me ask earlier, and I ask this for most cases, and such as yours. I want to know if you have any financial interest in any other liquor license within the state of Maryland.
I am only an investor. So I'm not an officer, I'm not a owner, I'm not a manager, I'm only an investor in the one location at Riva.
But you do have a financial interest, and it's, you say, one other place?
Correct.
And what is the name of that?
Four Futures AAMG, which operates as Squisito Riva, which I just came off of that license. We just were a part of that hearing.
Okay.
And that's a Class H license, right?
Yes, I believe so.
Okay. Thank you very much for answering that. I just want to reiterate, and if I understand Mr. Brown correctly, and I believe I do, you're looking for an approval as it applies for the sale only for your private label of wine that Tuscan Prime specifically sources and imports from Italy.
Correct.
And that's all you're asking for?
Correct, for the Tuscan Prime private label. There's 3 SKUs. Correct.
Yeah. And that's important. I just wanted to make sure that everybody understood that.
Yeah, we don't want to sell alcohol. We're not a bar to go. I mean, this is just, we want to implement our wine club, which is our 3 private SKUs.
Understood. Okay, thank you. That's all questions I have at this time.
Commissioner Snoops, questions?
No questions.
All right. Ma'am, we're going to let you speak now in opposition to this request. So if you could just give us your name and address and try to keep your comments brief to about 3 minutes, okay?
Well, if it's just going to be their wine labels, there is no objection.
Okay. Well, thank you for making it easy, taking up less than 3 minutes. And if you could just give your name and address for the record. So that we
Julianne Sullivan, 1504 Stacy Lane, Annapolis, Maryland, 21409.
All right. Thank you, Ms. Sullivan, for being here.
Thank you. Appreciate it.
Any additional questions from the board?
No, I have no additional questions.
Mr. Brown, Mr. Mayo, anything you want to add?
No, it's a late hour.
Thank you.
Sure. I was trying to be fast tonight. I hope I was.
Did a great job.
This time.
Okay.
Yeah.
So there's no additional questions by any of us. I'm going to go ahead and make a motion at this time then. And the motion is to accept the change in class for Tuscan Prime reiterating that this concerns only those private labels from Tuscan Prime. So I'm looking for a second.
I second.
Very good. All those in favor?
Aye.
Nobody asked you, Sam. Thank you.
Thank you.
Lots of luck.
Thank you. Good night.
Thanks,
Good
everyone.
night.
Moving right along. Next case is Las Delicias, Lemus Castro Corporation.
We'll wait reading.
Thank you, Mr. Lyman.
Sit down. Actually, you got to stand. It's fine.
I'm sorry, remain standing. Raise your right hand. Good. Caught me sleeping there. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may be seated. If you could, state your name and address for the record, please.
Juan Lemus, 1042 West Central Avenue in Davidsonville, Maryland, 21035.
Bersabel Lemus, 1401 Justin Court, Annapolis, Maryland, 21403.
Good evening. Again, Mr. Chairman, Commissioner Snoops. We're here for a new Class H beer, wine, liquor license for a location that actually previously had a liquor license. My clients acquired the interest in the property, the lease, and the restaurant that was operating there. However, the old owner disappeared, and we didn't get the liquor license transfer sorted out. So
Mr.
we're
Lyman,
here-
I'm sorry, could you please quickly identify yourself for the record?
I'm very sorry. Thank you, Chief Inspector Ford. My name is Brian, last name Lyman, L-Y-M-A-N, on behalf of the applicants.
Thank you.
So we're here on a location located in a shopping center. It's a small shopping center not too far from the board's offices on Admiral Drive. It's a fairly small location. It's about 1,800 square feet, and it's a Salvadoran restaurant. The name of the restaurant is Las Delicias Latina, and that's a slight change in the prior trade name. I think it used to be just known as Las Delicias, and we didn't have the Latina part of it. I present to you brother and sister here. We've got Marisol is how I know her. She's the main proprietor who actually operates the restaurant. She's been in and operating this restaurant for about 8 to 10 months, and alcohol would help her business, and I think it would also help their customers enjoy their meals at the restaurant. And we have her brother, who's the qualifier. That's Mr. Guillen. He is a naturalized U.S. citizen from El Salvador, and we have two other investors who have been identified in the documents who aren't before the board tonight. But this is essentially a family concern. I represent Marisol's sister, Veronica, who actually operates a restaurant on Forest Drive called El Rincon Latino. Now, that's in the city's jurisdiction, but they've had a liquor license successfully there. Actually, Marisol's sister went and got her own license from the city liquor board a number of years ago, and did not actually have counsel until we figured out that she was not a U.S. citizen and didn't own the requisite property. But we got through those issues, and that's why I got to know the Lemus family. And they are sort of the American story of entrepreneurship, hard work, and trying to make a better life for their families and their children. And they know how hard the restaurant business is. Marisol has worked at El Rincon Latino. It used to be called Lupita's Restaurant. I don't know if you're familiar with it. It's on Forest Drive, right across from the seafood market, for about 10 years. So she knows the ins and outs of the restaurant business. She knows what needs to happen as far as serving patrons and catering to, a class of customers who work hard oftentimes in the daytime, immigrants from El Salvador, and who come to a restaurant late in the evening and would like to enjoy, mainly a beer or a glass of wine with a meal. But generally speaking, the customer and the clientele that she's catering to are folks who work hard in long hours and are looking to get a meal sometimes later in the evening. I believe all of the paperwork in the file is in order. You have the floor plan. They had hoped to get karaoke. However, we needed to identify exactly where it might be on the floor plan, and we decided to withdraw that request at this time, knowing full well that the board would require the specific location be identified and cleared by the county planning and zoning officials as far as the distance limitation from residential property, because there is a residential property immediately behind this shopping center. If the board has questions of Marisol or her brother, I'm more than happy to have the board inquire. I don't want to take up more time than is necessary. And I do want to make sure that we cover the appropriate statutory factors under alcoholic beverage cannabis. Cannabis. It's going to take some getting used to, Jimmy. That's the alcoholic beverage article. Let's just stick with that for now. Section 4210. I believe that, without going into too much detail, there is a public need and desire for this license. My client has explained that her customers, who had been customers of the previous proprietors, were upset that she wasn't able to offer alcoholic beverages when they took over the restaurant and weren't able to work out the transfer of the license. The existing license holders, I don't think, will be greatly impacted. I'm not even sure there's another license holder in the shopping center. I think they're the only license that will be in this particular center on Admiral Drive. They offer Salvadoran fare to a community that obviously they're part of, and I think that is a growing part of our community here in Anne Arundel County. And offering alcoholic beverages with those services and those meals that are served to that community is important, and it's important for the board to acknowledge and make sure happens for the Latino and immigrant community. The uniqueness of the services, they offer a great Salvadoran menu. It used to be, I think, French and Salvadoran cuisine under the prior owners, but I don't know that you guys are offering any French food, are you? No French food. This is pretty much traditional Central American recipes, and I think that with the addition of alcohol, they can really help their customers have better experience in the restaurant and enjoy their meals a little bit more. I don't think that there was going to be any significant impact on the health, safety, welfare of the community, and the shopping center has been in existence for probably, and I used to know the answer when I actually prepared the application, for I would say over 20 years, that this same shopping center, including the parking and traffic patterns and convenience in its proximity to several apartments and condo communities is appropriate. Those, I think, are the basic sort of recitation of the factors under 4210, and I'd just like, if Marisol or her brother want to say anything to the board in support of their license, just go ahead and speak up and tell the board why you think you need an alcoholic beverage license.
You really need the liquor license because customers are really complaining about, they need some type of beer. And it's hard right now with the economy, just support our restaurant just with food, because if you see everywhere is food trucks, it's really hard for me, especially just serving food and no alcohol.
Thank you.
Yeah.
Thank you, Mr. Lyman. Mr. Chairman, questions?
A couple very quick ones. Same thing I've asked people prior to you, and I'm going to address this to both of you. Ms. Woolen first. Do you have or possess any financial interest in any other liquor license in the state?
No.
You understand? Okay. And do you, sir?
Yeah, I don't.
You don't? Okay. All right. Well, thank you. That answered that. We got that out of the way. I noticed you have a Hugo Alberto Castro Martinez as 40% interest in it.
Yes.
Is he going to be active?
Yeah, he's my husband.
Oh, okay. Yes. Well, that answered that question. Okay, fine.
For a while, anyway.
Right. Yeah, depending on how many hours you had to put in. Juan Jose Lemus?
He's my dad.
Oh, okay. All right. Well, you.
I tried to tell you, Mr. Chairman, it was a family enterprise. They're investing their family assets in the enterprise.
Do you know if either of those have any other interest in any liquor establishments in the state?
No, they don't have any liquor license.
Okay.
Yes.
Very good. Thank you. That's all the questions that I have.
Thank you.
Commissioner
Okay.
Stoops, any questions?
No questions.
Mr. Lyman, anything you want to add?
Nothing further. Thank you.
All right, thank you. Mr. Chairman.
No further questions. Thank you. And with that being said, I'm going to make a motion. I'm going to make a motion that we go ahead and approve the new license for Las Delicias. And we wish you a lot of luck. And I'm looking for a second on the motion.
I second the motion.
Thank you, Commissioner. With that, all in favor?
Aye.
Okay.
Thank you, Mr.
You got
Chairman.
it.
Thank you, Commissioner.
Thank you, folks. Good luck.
Thanks, guys.
Thank you.
Next case is Fodina, Ohodina LLC, Frank Hui Du, member, Inspector Ace Chenoweth. This is for a new license located at 4141 to 4143 Mountain Road, Pasadena, Maryland, 21122, for Class H beer, wine, liquor, entertainment, restricted to multiple TVs only, and Sunday license. Thank you. If you could please raise your right hand. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you very much. You may be seated, and if you could both state your names and addresses for the record.
Sure. Christopher DiCarlo on behalf of the applicant with the law firm of Whiteford, Taylor & Preston.
My name is Frank Du. I live at 14423 Fairdale Road, Silver Spring, Maryland, 20905.
Thank you.
All right, counsel, we'll turn it over to you. You can go ahead and present your client's case by way of proper testimony or a combination of both.
Thank you very much, and good evening, everyone. Thank you so much for the time. As just indicated, my client is in here, Fodina LLC, and Mr. Frank Doe is the 100% owner for a request for a Class H restaurant license, as well as restricted music because he'd like to have about three TVs within the premises as well. I will proffer, and certainly Mr. Doe can answer any questions for you, that he's asking for approval of this relatively small family restaurant that's located in the Lakeshore Plaza Drive in Pasadena. It's about 2,500 square feet. It will have a small bar that's about 4 to 6 seats. Most service will take place within the dining room at the tables. He is alcohol awareness certified. He answered the questions in his application truthfully and is still up to date. He also would testify that he does not have a financial interest in any other license. He has previously worked in Silver Spring in restaurants that his family owns, and he wanted to bring that faux Vietnamese style experience here to Anne Arundel County in this area, which there are no restaurants within that area, I believe, that are facilitating that need right now. As I indicated, he is requesting 3 TVs that'll be not really for a bar or anything like that, but more to have, I think he indicated he'd like the Travel Channel in the background, Food Network, golf, things of that nature while people are eating, and he really just wants to be able to allow his customers to enjoy a drink while they're enjoying their dining experience. With that, I will rest and turn it over to Mr. Doe if he has any questions.
Mr. Chairman, any questions?
No, I have no questions.
Commissioner Snoops?
No questions.
All right, well, then we'll turn it over to the board
With a
for
smile.
deliberation and decision. Mr. Chairman.
Yes, I'm going to make a motion that we accept the new license. I understand that this Class H is beer, wine, liquor with entertainment, but it's restricted to TVs only.
Yes.
Very important you follow your restrictions, and a Sunday permission or license. Okay, with that, I make a motion that we accept the transfer, or the new license, I'm sorry. Looking for a second.
I second the motion.
Thank you, Commissioner. All those in favor?
Aye.
Aye.
Thank you very much.
Lots of luck.
Thank you and congratulations. Moving along, we have X Golf Annapolis, T to Table LLC. Thank you very much, Mr. Carter. If you could please remain standing and raise your right hands. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated, and if you could, please state your name and addresses for the record.
Raquel Patel, address is 401 South
Thank you,
Cherry
man.
Grove Avenue, Annapolis, Maryland, 21401.
I'm Robert Cannon, 450 Century Vista Drive, Arnold, Maryland, 21012.
Out of order, good evening, Linda Carter, Carter Law, 11720 Beltsville Drive, Suite 100, Beltsville, Maryland, 20705.
Good evening. Benjamin Carter, Carter Law LLC, 11720 Beltsville Drive, Suite 100, Beltsville, Maryland, 20705.
Thank you.
All right, thank you, Ms. Carter. Go right ahead.
Thank you. This evening I have with me the applicants Rakil Patel and Robert Cannon on behalf of Tee to Table LLC trading as X Golf. We are applying for a Class D beer, wine, and liquor license with entertainment and Sunday privileges. I just distributed an exhibit book to the board. I'd ask that be admitted to evidence, please.
This will be admitted as applicants 1.
Thank you. So X Golf is a very unique concept. I'm not sure if anyone on the board golfs, but it takes the Top Golf experience and takes it to a different level. Instead of having a competition over a driving range, you actually can play simulated golf courses. All in the environment of a climate-controlled indoor establishment. It's unlike anything else in Annapolis, and golfing, alcoholic beverages are popular for golfing, and that's why they're pursuing this class of license. Well, the reason they're going for a Class D is that the overwhelming majority of their revenue will be related to actually golf, not food or beverage sales. We reviewed a pro forma, and they anticipate that more than 2/3 will be golf related. Of the remaining third that'll be food and beverage related, the majority would be alcoholic beverage related, so they would not be eligible for a Class B or a Class H license. But as the Exhibit 1 in the exhibit book indicates, there will be a menu available during all hours of operation. And while limited, it's consistent with golf course fare, which is kind of the experience that they're trying to create out of a golf course, but in an indoor climate-controlled setting that golfers can take advantage of year-round. They will be accepting reservations just like you would for a golf course. So it really is a simulated golf setting as opposed to competition at the driving range like Topgolf. I'd also like to turn the board's attention to Exhibit 3. There are a number of petitions that were signed by supporters of this application. I counted 62 signatures in support. I'd like the board, appreciate if the board would note that.
Yeah, all the exhibits that you submitted, Mr. Carter, will be accepted by the board.
Thank you. If I could make a number of proffers, please. The applicants and I have discussed at length the board's rules and regulations. They're very familiar with them. We discussed them for probably 2 hours on Thursday. They understand, this is a privilege, and they take this responsibility very seriously. They are dedicated to having an establishment that is compliant with all necessary rules and regulations. And I respectfully request that this application be accepted, approved. Oh, I also, they've both taken the tips class. We have not gotten the results back yet, but we anticipate getting them back in the next couple of days. And given their daytime jobs, Rob is a software engineer and Rakil is a podiatrist. We expect them to pass with flying colors.
All right, anything else, Mr. Carter, before we turn it over to the board for questions?
I have not, neither one of them has an interest in any alcoholic beverage license anywhere else in the state.
Okay, so you don't mind me reading that to your clients and letting
No,
them
you can ask them directly, but we discussed this because it's a Class D.
Yeah, no, and I appreciate it. What we want to do is we're going to put it on the record as a question and answer. So this is to both of you. Do either of you have or possess any financial interest in any other liquor license in the state of Maryland?
I do no, sir. No.
Answer both no. Thank you very much. X Golf Annapolis. I'm impressed. I wonder if it could help my golf game.
It can. We offer teaching. We offer lessons.
Okay. No, I have no other questions. I see where you're going after a Class D, as Mr. Carter explained, so I have no questions.
Commissioner Snoops, any questions? Mr. Carter, anything you want to add?
I'd respectfully request that the board approve this application. I'd like to thank the board for its time this evening. I know it's been a long one.
And for moving us up.
Mr. Chairman.
Yes, just to reiterate, this is a Class D license for beer, wine, and liquor on sale only.
Correct.
Don't let it walk out the door. With entertainment and Sunday license. I'm going to go ahead and approve this new license, or at least make a motion to approve it. Looking for a second.
I second the motion.
Thank you, Ms. Snoops. With that being said, all in favor?
Aye.
Aye. Congratulations.
Thank you.
Thank y'all
Thank you,
so
everyone.
much.
Thank you.
Okay, it's been a long night. Thank you to everybody for your patience. We have one final case, and that is back to the Point Crab House and Grill. Ferry Point Restaurant, LLC.
I'm assuming, Mr. Katz, you'll waive the reading? That
Yes.
all right?
Thank
Okay,
you.
Thank you.
Yeah, Chief, if you want to dismiss them, if that's what your wish is. then you're
Inspectors, you have an option to stay and listen to this case, or it's late. You are certainly free to go. Up to you. Please remain standing. I'm sorry we have to do this one more time. That's okay.
welcome. Again,
Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you very much. You may be seated. And once again, if we could all state our names and addresses for the record.
thank you. Sorry about that. I wanted to get their attention.
Evan Pickett, 203 Benfield Road, Severna Park, Maryland, 21146.
David Katz, 2410 Evergreen Road, Suite 105, Gambros, Maryland, attorney on behalf of the applicant.
Julia Jones, 300 Kingsbury Drive, Annapolis, Maryland, 21409.
Robert Jones, 682 Fairview Avenue, Annapolis, Maryland, 21403.
And before we get into the nuts and bolts of the presentation, we have 3 individuals who have signed up in favor of the point. Looks like it's Elizabeth Kirst, Samantha Kohler, and a Leonard. I can't really make out the last
Those
name.
are our managers. I don't know why they did that.
Oh, okay.
They took off.
They were here.
Okay,
We
gotcha.
told them they could go after the
Okay,
first
nobody else is planning on
You made
testifying
them
in
come?
support or in opposition
We
to
didn't
this.
make them. They chose to.
They chose.
Okay, great. All right. Well, they were here in favor. So, all right. Sorry to interrupt, Mr. Katz. Go right ahead.
Thank you. Good evening, Mr. Chairman, Commissioner Snoops. Again, appreciate the opportunity to be back before you this evening. I will try not to be as long-winded this time, but we are here before you for 2 requests. One, to remove the restriction that limits alcohol service in conjunction with a meal. And secondly, to it's effectively a request for clarity on the ability to play live music piped through the system, through the existing music system. There is no restriction that exists today on the license that limits amplified music, and I think we are requesting clarification from the board that amplified music does not mean live music through the pipe system, which is permitted via the code with a music license. So I'll start with the first request, in that we requested the restriction be removed. Without, needing to preserve the record and reiterating the arguments that were previously made, we feel as though the strict interpretation of, let me back up. We feel that the adoption by the annotated code with a Class H license, that the sale of food equates to more than 51%, effectively does the job for the board in ensuring that the operation at the point does not and cannot become a rowdy bar. And since my clients have operated, it has been the furthest thing from that. And such a removal would not be detrimental to public health, welfare, safety. In the file, you have sales figures dating back to 2015. I would ask you to take a look at that. I can also provide additional copies, in front of me, I'll recirculate. But the P&L statements that have been provided to the board demonstrate that the percentage of gross sales related to the sale of food has made up roughly 70% of the overall gross sales of the business. And in fact, since 2015, you'll see a steady increase. More and more food is being sold, albeit via 100 or so basis points above the 69% threshold set forth in 2015. We believe that strict interpretation of, as you heard previously with regard to the violation this evening, it's an impossible standard for the applicant to meet. There are far too many circumstances in which a potential violation, viewed in strict with this strict interpretation, it's far too burdensome on the business and goes against every reasonable principle for operating an establishment like this. I think that the evidence demonstrates that the Joneses have turned the point into an award-winning culinary experience. Every year they're awarded for the quality of their restaurant and the high quality of their food, and that a restriction and the experience as a whole. This is a restaurant that doesn't take reservations, so it really becomes an all-evening experience given the long wait times. But the food is offered effectively at every stage once you go there. And there is, the restaurant is not organized or situated in a way with the outdoor seating, with the bar, with the high tops, and the dining room that would lead to or in any way promote this becoming a bar. In fact, it's been the opposite. So with that, we think that the sales clearly demonstrate that this is a restaurant first and foremost. And we think that the code itself, requiring that each licenses have 51% of sales, be that of food, effectively do the job for the original restriction implemented in 2011, ensuring that it's more food than alcohol. And then frankly, it's just impractical and unreasonable to require that with every order, at some point there has to be food. Because, again, family emergencies, being the third wheel, as I spoke about earlier, there's just far too many instances that are outside of the applicant's control, the license holder's control, that could lead to a potential violation as the restriction is interpreted today. So for those reasons, we ask that the restriction be removed. With regard to the music itself, I think the record is unclear in 2011, between the chairman at the time and the attorney, Fred Delavan, in terms of the request for music, because there is mention, and do you want me to play the audio?
We've got a transcript.
You've got a transcript of it?
Of the pertinent part.
Of the pertinent part.
Yeah, I mean,
do
you have a copy of that?
Yeah, we weren't provided a copy of the transcript. We were provided a copy of the audio. So we've listened to it. And
Just the small portion that we have.
Right.
Yeah. Okay.
yes. And, it does specify that, I believe the chairman does specify that the music be limited, any live music be limited to 2 musicians and not be amplified. We believe that the intent of that statement, again, no restriction was placed on the license as a result. No restriction stating that live music not be amplified was placed on the license. That doesn't exist today. But there is this statement that exists in the record. We believe that meant independent amplification. We don't want musicians coming in with their own stereo equipment, their own speakers, playing loud music. What is permitted under Article 11.1102 with regard to a music license is that you're allowed pipe music, may allow piped in background music. What the point has been doing is connecting the two live musicians to the system that's piped in and maintaining a legal decibel limit with that music. So we're requesting clarity that they be allowed to do that. From our perspective, live music that's piped in or record music, CD music, Pandora, piped in all from the same speaker, there is no difference. And the code clearly allows this amplification of music at a legal decibel limit. So we don't believe it was the intent. And again, if you go back to the record, as they've continued to request annually their outdoor seating license, in some instances it's noted that two musicians are permitted, not amplified. Other years there's no reference to it altogether. It is not the intent that two live musicians have independent amplification. But what we would like clarity on is that they are permitted to effectively connect to the permitted per code piped in music, provided it is at the legal decibel limit. So those are the two requests that we make before you this evening. You know, the music, I believe that the request with regard to the alcohol restriction is practical. I feel like the testimony from the inspectors clearly demonstrate that this is an impossible thing to police and an impractical thing to police. From a music standpoint, I mean, I know that this is near and dear to my client's heart. You know, they employ a lot of independent musicians, and you know, I don't want to give the sob story of it's a tough economy, but they really provide a platform for a lot of musicians to come out, to showcase their music, and to earn some money doing so in front of I wouldn't say in front of a large crowd, but as part of a large gathering. You know, it's always a very busy restaurant. And from our perspective, there's absolutely no difference between background music at 65 decibels or lower or live music at 65 decibels or lower. In fact, it allows for the control of the music because they independently control the decibel level versus, call it non-independent amplified music competing with background noise from the restaurant. Everyone gets louder and louder and louder as they try to be heard, right? Well, now you have controlled piped in music, whether it's pre-recorded music or live music at the legal decibel limit. So I would effectively conclude with, respectfully, that I think the evidence tonight demonstrates that a restriction requiring simultaneous or within a set period of time there has to be food with the alcohol, I think it's impractical. It goes against how every restaurant operates. As a matter of fact, I mean, really how drinks and food are ordered, I mean, they go through sort of two different systems, two different tickets of ordering. So it's really impossible to govern how that restriction can be complied with. And I think that this sales speaks to everything. Sales speak to the fact that this is a restaurant, and sales clearly demonstrate that this is a restaurant. 70% of their sales are food. This is not a bar. It's never been a bar. The Joneses don't want to operate a bar. And the H license effectively don't allow you to do it. And with regard to the music, again, we don't see the distinction. There is no restriction on the license that expressly precludes the ability to play live music through a legally permitted piped-in system as long as it maintains the legal decibel limit, and that's all we want to do. I think that's what we're permitted to do under Article 11, and I believe there's no restriction that speaks otherwise. So I think we just want clarity on that because, respectfully, Chairman, you noted that you believe that there was 4 violations in your previous statement, and again, I believe I disagree. In that I believe whether it's background music, live music, if it's piped in through the system that's permitted in the music license, and then there isn't a restriction tied to it, and as long as you're within the decibel limit, it's permitted. So that's what we request this evening, and I would yield to you from there.
Thank you, Mr. Katz. Mr. Chairman, questions?
I have mauled and read and lost some hours of sleep, but that's okay. It's part of the job. I understand, I believe, Mr. and Mrs. Jones' situation. But I also have gone back through the records way back. And I've taken certain notes that I think might lead to some questions. But what I really want to do is hopefully come to some kind of agreeable situation that will work for the licensees and the board. And but what I'd like to do is I'm going to start off by reading a few things, if I may. And,
sure.
Just to kind of
go right ahead. Yeah,
just kind of clarify what I know and so forth. We're talking earlier years too, by the way, at first. In 2013, there was a complaint about loud music. Oh, thank you. In 2014, there was a complaint about amplified music, loud in the fact that the doors were all left open during the amplified. That's the way the complaints read. The third complaint was August 14th of 2014. It talked about noise from the patrons and the music. The fourth one was in 2014, October 22nd of 2014, talked about loud music and general patron noise. Chit-chat, whatever the case, laughter, I mean, I understand that. In 2015, there was a complaint in reference to truck noises, and I think I was part of an investigation back then. Yeah, but and that's not really what I'm looking at tonight. I just want to explain to you we have this as part of the records. Then there was a complaint in reference, this was in August 31st of 2015, that talked about truck noises, but it also said that there was a lot of noises coming from the fact that the doors weren't closed. The seventh one was a protest that never really developed, but there was 19 signatures from local residents. Well, that's what I have. But, I mean, maybe they're not all local. I'm sorry?
It's like 4 different houses. But.
Okay. Well, I think the point that I'm getting at is the board has received this information, and this is just between 2013 and 2016. And since then, I believe there's been some communications between the chief, the inspectors, and the principals, the two of you. I think the one that we received.
I know of.
No, we haven't received any communication at all aside from the.
Well, there was communications between the chief and you, I believe. No?
No, not prior to the.
What year? What?
Not prior to August.
Oh, no. I didn't necessarily mean prior to August.
So since 2016, just this year?
Yeah, okay. Yeah, thank you for clarifying that. We did receive a complaint today. And maybe because they knew that you were coming in for a hearing and they wanted to make it, and we understand that, we can read into things, but at the same time, I believe this was shared with Mr. Katz.
Was.
And he may have shared it with you, I don't know, but he has a copy of it. It's from a Brian Oates, who I think might be a local, but, I don't know. He's the one who signed this. It's dated today. And his concern was, again, the noise, the music, the fact that the garage doors are left open and so forth. There was a period where evidently there wasn't a lot of complaints registered, and that's to your credit. But with these restrictions, they were put on initially by the board in 2010, I believe it was, and changed in 2016 slightly. And the way I read the restrictions is the one restriction limits you to acoustical instruments, non-amplified. And that was based on a reason that this travels across the water. I'm on the waterfront, you're on the waterfront. We understand how that works. It seems like you can leave there at 63 decibels and go across the creek and it gets there at 63 decibels. Water just does that. But my concern is the residents that are living in your area. How are they feeling about this today? I don't see anybody here, which I've taken note to. I think I'm straying off a little bit. I want to get to a question, but I'd like to make my point.
Right. No, you can comment all you want right now, Mr. Chairman.
And what I want to do, I want to get to this. We have a series of complaints, and we have things, and I personally feel, this is me, that the commissioners at the time they put these restrictions on had a reason. And unless that reason has disappeared, then I think we still need to address it or to look at it. And I think that's a point that is really sticking with me. And I can tell you the last thing I want to do is, let's say, lift the restrictions, and then all of a sudden we get a bunch of upset neighbors because the point has done whatever they wanted to do as far as the music and so forth. What I'd like to do is hopefully come to some kind of an agreement, like I said earlier, where we can maybe soften the restrictions, but at the same time protect those residents who we are obligated to look out for. And I think that's important for all of us to realize, whether it be 5 or 6 or 50 or 60. A lot of your patrons come from outside the area, and they could care less what kind of noise that they produce or they're part of. Those that live there, of course, they have a different concern. So with that being said, and also the fact that I'm still concerned and upset about the multimedia blitz that went on for a while.
Which, by the way, is why no one's here.
I'm sorry?
That's why no one's here, because we were too afraid to ask people to come and support us after your reaction to our outreach for support.
And Mrs. Jones, I actually appreciate that because I expected a busload.
Yeah.
I really did. But
now, Mr. Chairman, I do want to point out that while I understand, the board's desire to, whether it's 5 residents or protect 5 residents or 50 residents, I just want to note that complaints don't mean violations. And there is a world, as evidenced by this evening, the hearing in 2010 was hours and hours. It was repeat opposition and opposition and opposition and opposition. And that was because Magothy Seafood was a bad actor and a bad operator and loud and obnoxious and irritated everybody. I'm assuming, given the amount of opposition that came out. Now we have 12 years of good operators, of a great culinary experience. And sure, people will complain, but I think if you weigh the limited amount of complaints over 12 years or 13 years, in fact, there are complaints, but the fact that we're here this evening and there is no vocal opposition, and the fact that it is one of the most popular restaurants in the county, and a destination for a ton of people speaks to the quality of the restaurant and the fact that the Point, my clients are great operators and doing everything they can to be great neighbors to the residents around them. So I think people, can wake up on the wrong side of the bed and they heard a bad sound, they heard a song they didn't like and they're calling up and complaining. Nobody ever calls to tell you how great things are going. It just doesn't happen, And I think if that did happen, there'd be thousands and thousands and thousands and thousands of calls saying the Point is great. It's one of the best restaurants in the county. It's a jewel that needs to be preserved because it really draws a lot of business versus, a handful or however many complaints have been had over the last 13 years. So there really is a clear distinction on what previously was there and the amount of animosity it created for the community versus today. And I respectfully request that the board take that into consideration because you really have first-class operators here that are operating a first-class restaurant and don't want to be bar owners and want to be good neighbors. And I don't see how the board can make a distinction of piped in pre-recorded music, piped in live music, as long as it's in that system and it's 65 or decibels or below. Last thing, based on the complaints, I think, on some of the music complaints from a handful of years ago, more, they updated the sound system. It's now a sort of a state-of-the-art sound system where they really can control the sound, and that's what they've been doing. I think that's why perhaps the complaints are limited, although still existent. I mean, I don't know that you can ever make everybody happy. So,
thank you. If I may, I have a couple more questions for the Joneses. Do you have a decibel meter?
Yes.
And when you use it, how do you use it? Where do you go to use it? Do you go right out the door and use it? Or?
Usually we use, inside the restaurant is, it ranges, right? On those 3 months of business that were busy, the restaurant itself will run around 50, 55. It gets loud. But in the past, when these complaints were more frequent, it was generated by one guy. There were complaints that we would get where there was a party across the creek on 4th of July. We didn't even have music. So a lot of times customers are confused. They just think it's us. When I was actively measuring and, I would go outside as far away from the restaurant as I could to take measurements. I take them inside the measurements. So yes,
I would also note, Mr. Chairman, sorry to interrupt you, but it's a marina. You have all kinds of boats coming in to dine. That's how a lot of people choose to get to the restaurant. These boats, nowadays have very serious sound systems themselves. So I think that a lot of it is not per se from the restaurant, but from perhaps patrons. I mean, these wakeboard boats now, and I've seen a lot of them come into the marina. I mean, it's built for wakeboarding and listening to music while you wakeboard. I mean, these huge speakers.
They drive us crazy.
So I mean, I could see where some of those complaints probably are resonating from the boats that are coming in versus the actual live music per se that is being played.
I worked the waterfront as an inspector, and I carried a decibel meter. And the rules and regulations for those are you're allowed up to 65 decibels until 11 p.m. and it drops to 55.
Uh-huh.
And we would calculate it and make sure that our decibel meters were, working properly. You go to the property line. So in order to, the best way to do and check it is take that decibel meter, walk out to the waterfront or walk out to the side property lines and take your readings there. Yeah. Because if it's getting past there, then you're interrupting the peace of your neighbors or could possibly be interrupting the peace. And I ask that for a reason because we've put restrictions before, if I remember correctly, I could probably name the establishment, where they had to test every hour when they had entertainment and keep a record of that. And I'm not saying that's what I'm suggesting, but the whole point that I'm getting at is that it is important that you know, and I know you're there a lot, Mr. Jones, and I'm sure Mrs. Jones is, that you know what's going on, not leave it to the opinion of your managers, and who are more than happy, your waiters and waitresses and managers are more than happy to do what the customer wants. I mean, between...
I think it's also important to note that I think, if I'm understanding, we haven't had a sound complaint in 7 years. And we've been doing this, you know, when we say we're piping it through a new system, like, the musician does not have an amplifier in front of them that is playing music in front of them. It is distributed evenly throughout the whole. And another thing is, this music is done by 8 p.m. So there is no after 11 p.m. You know, we try to be very, very respectful and try to be good neighbors. And I would also say, for every complaint you get, there are real estate agents that use the point to sell homes in our community, because it is a draw for people to come. And people tell us all the time, we bought our house because your restaurant is here. So, and again, I think, as Mr. Katz was saying, you may not hear all those things, but I think no sound complaints in 7 years is a pretty good record for what we've been doing, and we're not asking really to do anything different.
And to add on to that, you know, when we were at those hearings in 16 and prior, when that was all going on, and we were told you're allowed 2 musicians, non-amplified, under 65 decibels. That was written on the outdoor, renewals every year. So again, we thought we were, in compliance. I think what Dave's saying about the clarification is this amplification term, because we are using it through the same system we play our background music on. Also what Joel was saying, we don't want to be bad neighbors. Like, the musicians come to add to the experience of the restaurant. We're not bringing in our musicians to generate more business. We don't have them on the weekends. We never applied for a music license because we don't want a big band on it. We don't want to have anything to do with that. But one acoustic guitar is what it is most of the time. And it's just nice. And, another thing, to kind of follow up with what Dave was saying about, we have actually just 6. We have 6 musicians that rotate every other week. These are professional musicians that feed their families. These guys, they'll be there in February on a Tuesday at 5 o'clock, whether it's snowing or raining outside. Like, we're committed to them. They're part of our team, and I just want to make sure that's understood as well.
Yep, thank you, and I do, and I appreciate that. What instruments are we talking about as far as your musicians? You say you have a regular group that you rotate and so forth. What are we looking at, guitars? Or? So
mostly I'd say there's 6 total. So we have Tuesday, Wednesday, Thursday from 5 to 8. So Brian Ewald, Dan Haas, Jordan Sokol, Aaron Yieldhall, Aaron Hawkins, they're all solo acoustic guitars. Okay. Sometimes Jordan will bring a friend, and there'll be 2 of them. But there's, they're playing acoustic guitars, and it's or possibly a bass guitar. So there's no percussion. We understand we don't want to be loud. We cut it at 8. It's low key ambient music, and we didn't go after that music license because we don't want that a Van Halen band coming in and blowing up the creek. So that's, I think, where some of the miscommunication came in, because when they used non-amplified, I took it as not a 5-piece band. Like, we don't want that anyway. So we also don't want the music license. And then we were told you're allowed to have 2, up to 65, non-amplified. And then the inspector sees the microphone, and it makes sense. I can see where the confusion happens.
How many speakers do you have in-house and outside?
So total, there are 1, 2, 3, 4, 5, 6, 7, 8. They're about this big. And then we recently modified that system and we added 2 more. So basically we were taking the speakers that were a little too loud in the corner that were facing the restaurant. So we have complete control. I mean, we could put limiters on them. It is completely controlled at the host station, where there's, if the musicians, they think, it happens. Sometimes they turn up too loud, and we, back in the day, we'd be like, you got to turn down, you got to turn down. It was much more monitoring, but now we just turn them down. If, we know exactly it's the same volume as our Spotify. There's a plug, they plug into a box. The box goes to our house amplifier, and the controls are, they're under our control.
Mr. Chairman, I just want to make one comment, for the record, just to ensure that I preserve this. I believe that there's an ample case law that states that restrictions can't go beyond the statutory authority that was intended. And, I believe that there are caveats to that. Consent agreements, right? What I want to preserve for the record is, with regard to the music, I believe that, and a restriction doesn't exist as it pertains to music. There is not an express restriction on the music portion of this license. But if the code permits piped-in music, I don't know that the board can impose a restriction, whether it's live or recorded music, as long as it's piped in, which the code expressly permits. And then taking it a step further, again, understanding that that Attorney Delavan, on the record stated that they agree and acknowledge, we believe, again, that it was unclear on what really the restriction intended to do, and that based on the level of opposition that existed in 2011, and the fact that, this sort of all happened in real time during that hearing, regardless of the consent, I believe that there's justification to challenge the restriction in that, if Attorney Delavan believed that in that moment there was no other way to get the license issued but to agree to the restriction, albeit it was unclear, I don't know that the law allows for that restriction to continue to be valid if it goes outside the statutory authority. And a restriction that says you can't, the H license today, generally speaking, in the annotated code does not say you cannot, with an H, you cannot drink without eating first or at some time during. Doesn't say that. So that's where I really, I struggle with the validity of the restrictions, if in fact there really is a music restriction, and why I ask this board to reconsider those.
I hear you, as they say.
Yeah.
Don't necessarily agree with everything that you're saying. I'm not an attorney, but I've worked with them for years. And I believe that we have a right to put restrictions on. I believe that this board has a right to make those restrictions. And if the attorneys or if the licensees feel that it's unjustified, then of course you always have the right to appeal and, take it through the system. And, but what I'm trying to do tonight, what I'd like to try to do tonight is accomplish something that would help the licensees and at the same time protect the community and their serenity, if you will.
Can I make a suggestion then, Mr. Chairman?
Yeah, please.
And again, I would defer to my client, but, I don't believe it should be too restrictive, but I think that perhaps considering the percentage threshold, and increasing not by a lot, right? Because right now the H requires 5149. But what if we agreed to 55? That is a give to the community. It's a higher threshold than what the H requires. And again, in my mind, it demonstrates you're not just majority, you're more than majority food.
I took the liberty of, when I received the information for your last 9 years, looking at the percentages, I added those up, and for alcohol, not including sodas and all, it averaged out, when you take all 9 years, you add it up and you divide it by 9, it came out to 31.9% or 31.49% of alcohol during the last 9 years, all the way up until this past year. And that left, of course, 68 point whatever. But yet you're talking about 55, 45?
I am, because, there is a long track record with this restaurant. And not that this is per se the board's concern, but, there is a lot of value in a restaurant, of this caliber. And what I'm concerned about is if you have an off year, or if we really try to hold them to even though the numbers have been consistent, if we really try to hold to that strict number, there is too narrow a margin for error that puts the license at jeopardy. And that's what I'm concerned about. And that's why I'd say it is reasonable. Again, I think that the H now does the job that was intended.
Okay. I'm sorry.
Mr. Chairman, I'm sorry to
No, please.
interrupt your thought.
No, I want to hear everything. And I want everybody to please feel free.
Because again, and please, please disagree with me. But yeah, that's but at the time the license was issued in 2011, the annotated code did not require evidence of 51%. It didn't. So I could understand, the concern on the restriction and perhaps why the restriction was discussed. It was you can't be a bar. The whole debate was the H at the time effectively could allow for a bar. As long as you served too hot a day, as long as you served ratty, disgusting bar food, you qualified. You met the standard. Okay? The law has subsequently changed, and it requires that the evidence that a majority be food. So, in essence, the annotated code evolved such that the restriction could be complied with organically. And what I'm suggesting is an even higher standard. But I think it is unreasonable, given an off year. I'll tell you, after COVID, I think everything's off the table. How businesses operate, how people consume. It really is an ever-changing world, and I don't want for it to be so tight as to be overly burdensome when it's really hard to speak to the exact intent of the original restriction.
Here's in my opinion, and of course there's Commissioner Stoops and her opinions, because of the fact that a previous board put these restrictions on, I could look at it and say, I don't see any reason to take them off. They had a reason to put them on. I'm willing to agree with that. But what I'd like to do is try to maybe soften these restrictions in some form or fashion to make it a little bit easier. But at the same time, we need to keep reins on it. We need to make sure that, there aren't any flagrant violations, not that you would do it. You have two restrictions. One is, of course, the entertainment. And I know for a fact that you've had guitars, excuse me for that, guitars, but you've also had drums, percussions out there. And,
Used to, we stopped that.
I'm sorry?
Used to, we stopped that.
Okay.
Told
Well,
you
that's a
when
good
it
thing
came
to know. I'm glad you are. But the point that I'm getting is we can't let it get out of hand. You can't let it get out of hand. So what I'm thinking about, and this is just in conversation at this point, it's not a motion, is I'm thinking about when it comes to the alcohol beverage and policing it, if you will, which our inspectors have to do. And it's difficult, and I understand that out of 30 people, all of a sudden 10 of them or 12 of them ended up with food. But when they sat down, they didn't. And fortunately, our deputy chief was there long enough to see that occurred, and I'm glad he answered it honestly, and that helped clarify some of the issues. But I'm thinking right now you're at 31.49% as an average over the past years with alcohol, whether it be beer, wine, and liquor. Do you expect that to increase?
No.
Okay. So if we were to come to an agreement, instead of saying, when I say an agreement, I mean conversation-wise, the decision relies here, and I know you know that. But if we were to say, we will limit you not to exceed 35.65, or you're at 31.49, give you a little more, 35%. And I know alcohol goes up, but I also know food goes up as well. So 65-35 might be something where you would be obligated to send in a CPA's certified statement quarterly. I don't think monthly is necessary, but quarterly, saying that this is the percentage that you've done and this is it. I think that might make the enforcement of it and not have those inspectors sitting at your bar all the time watching people drink. But at the same time, give us the satisfaction of saying, we don't want you to be a bar. You applied for a restaurant license. We want you to be a restaurant license. And I don't see a need for a bar to have, 45% alcohol and 65% or 55% food. So that would be just a suggestion to talk about. And that's when it comes to the alcohol. As far as the music, if you have a loud group and you don't want it to go off the premises, do you close your garage doors at any time, or do you close some of them, or do you do anything at all?
What do you mean by loud group?
Well, whether it be music or just a loud, rowdy bunch of liquor inspectors out there.
We don't
or
have
something.
air conditioning inside there, so we can't close the doors when it's.
I'm sorry, what was the reason?
We don't have air conditioning.
Okay.
We're not climate controlled in there.
And I didn't know that, to be honest, but I wanted to make sure it hadn't changed since then. And so in the winter months, January and February, you close some of your doors?
They're all shut. The outside's completely, we only use it in the summer.
Mr. Chairman, could we exclude percussion? I mean, I guess perhaps could we exclude the ability to pipe in live music to perhaps it's maybe specific to the instrument, maybe it is acoustic guitar and not percussion?
I mean, that's something that we can consider.
And Mr. Chairman, on the 65-35, what comes to mind is, a hyperinflationary period when it comes to alcohol, where consumption isn't up, but for whatever reason, the government imposes a special tax on alcohol that significantly raises the price. So I'm concerned again that in a hyperinflationary period where you see the cost of alcohol for whatever reason, that resource is
Yeah.
available in limited quantities, that the cost goes up. That's.
That when you submit a report.
I mean,
And that's,
I mean, price of chicken might go up too, so your chicken.
Well, I agree.
With the price of crab meat, that probably comes to your food.
Yes.
You know,
and
guideline.
yeah,
In my opinion.
and I agree with Commissioner Snoops. There's nothing preventing you from coming back and saying, hey, look, you put a limit of 65, 35 price of something, and you could show us proof or give us some documentation that we're not beyond changing that or altering that. But we need to find a way, excuse me, we need to find a way to come to an agreement that will help you, but at the same time protect the community and the neighbors and so forth. And to just say that we're not going to worry about these restrictions anymore, we're going to take them all. I don't think that's going to happen, at least not if I have anything to do with it.
Well, since it's just conversation, and you're throwing out these ideas.
Yeah.
And then that these restrictions were placed 11 years ago, how much longer do we have to prove that we're a restaurant?
I would, because it's seasonal, like you say, June, July, and August are the heaviest 3 months, and I think you said 50% here, but I think in the written statement, we had 60% of your business was in that 4 months. I would suggest as part of this that, and we can even put it in a probationary period, if you will, for 1 year, see how it works out, and then you could come back to us with any suggestions that would either improve, or we may say to you, last year it didn't prove out too good. We had 3 complaints. And, we may.
I'm sorry.
Go ahead. No, please. No, go ahead. This is what I want to hear.
I understand what you're saying about a probationary period, and that makes sense, but I feel like we've been on probation for 11 years. And I feel like
and you violated quite a few of the rules and regulations.
Not the past 7 years,
let me finish. If you take the overall time, right, there were violations. And if that one visit from that one deputy chief was any sign of what was happening there on a regular basis, I'm not so sure that I feel comfortable agreeing with that.
But you did earlier say that you don't really look at violations previous to 5 years, right?
When it comes to fines and penalties, not that we don't look at your history, we always look at your history. If you remember, I mentioned to the one particular case that I looked at them and they had additional ones within a 10-year period. I could have gone back 15 or 20 or whatever. But we generally look at the previous 5 years and determine whether we see that you've cooperated or if you've done a good job, and if so, you could have a save violation tomorrow.
So I feel like maybe if we do look at the last 5 years, we can look and say we have done a really good job. And we understand why the restrictions were initially put in place, and we're not saying we disagree with why they were there. We're just asking to take our record and what we've done and treat us like most other restaurants in the county. Like I'm just not sure why we're continuing to be treated differently than other restaurants that are also in communities, that also have outdoor dining, that also have live music. I would just ask that we're treated the same, because I think we do a really good job and have a good track record.
Yeah, I mean, I mentioned to you earlier, I think you have a great place, and it's a fantastic place. These restrictions, you're not the only one that has these restrictions, Mrs. Jones. I mean, we can show Mr. Katz or anybody else, but the point is these restrictions were somewhat common when they felt there was a need for it.
Sure.
And that exact wording, to be exact.
Mr. Chairman, what if we met in the middle? What if it was a 60-40 split? And what if we, again, just conversation, what if we limited to acoustic music through the piped-in system at the permitted, I don't know that we could ever exceed the decibel,
Yeah.
Right? But it's again, trying to set it up for success. Percussion suggests louder,
Yeah, and I
take
know that,
out.
and that's why I mentioned it. And in my younger years, I used to play the drums, and I remember how they work.
I'd obviously, sorry.
No, I was just going to ask Mr. and Mrs. Jones if this is something that they might feel comfortable with.
Yes, I mean, I'm throwing this out there with.
Yes.
I mean, we talked a little bit about this. I mean, I think we're okay with 2 musicians through the piped, that's all we really want, through the piped system. That would be totally fine, and I'm okay with non-percussive.
Oh, yeah, absolutely.
That's, I think, totally fine. I think 60/40 is still aggressive compared to the 51/49 standard, but it's way better than 65/35.
I'm sorry, go ahead.
It's just, with what happened with COVID, it's scary. I mean, I have worked in this business a long time. I would guess every restaurant that I've ever worked for was around 60/40. Like, we are above the norm with our food to alcohol ratio. And to come close to that, and if we get in trouble, it just scares me.
Well, and that's what I was saying, and we can revisit this if you feel there's a need at some point. A year and a half down the road, you go, what we tried to do isn't working. We're losing money or we're losing customers. You'd have to validate it. You have to prove it. But like I said from the very beginning, I'm trying to come up with, and it's not that I want to compromise. I mean, I could make this very simple and say, no, we're not going to change the restrictions. But I looked at the violations from 2013 to 2016, and I didn't see too many complaints. I'm sorry, I said violations. But I didn't see too many after 2016.
That's when that guy moved. That's when he moved away. He was directly across the creek.
No, that's when you invited him over and introduced him to our baby and was like, we're a family, can't you see?
So if I may, then you would be open to a probationary period, right? At which time, if nothing eventful occurred that would want us to reconsider this, we could remove that restriction at that point, right?
Yeah, you could put a restriction on temporarily for a year, and then we could remove it after a year, or we could have them back in for a hearing after a year.
Okay, so that gives you a 1-year probationary period, if you want to call it that. And if we find that it's not working, that we're getting complaints, or we come out there and we see you're not following the rules, then we can call you back in here. But that gives us a year to hopefully try to work this out. And it's after COVID, so COVID is no longer an issue, hopefully. Never will again raise its ugly head. I think I would be open to, and want Commissioner Snoops' opinion, I'd be open to go ahead and do the 60/40 on the alcohol. And again, quarterly certified accountant, sent to the liquor board. We don't want to come ask for them. You need to send them to us. And when it comes to the music, I think you said it best. You would be okay with acoustical, right, using the amplified or using the in-house system, not to exceed 65 decibels at your property lines. And that's what we use as a rule of thumb for all establishments when we go out with our decimal meters.
And this would be, very much appreciate that. And this would be for a 1-year probationary period to determine that we've complied, and then perhaps, are you suggesting that after that probationary period, all restrictions would be lifted, or that those restrictions, okay, that those restrictions would carry, it would just be reconsidered after the year?
Good try, Mr. Katz.
No, I just.
Yeah, so I think.
I'm sorry.
I think the process would be, Mr. Katz, that if these restrictions are agreed to, consented to, or approved by the board, it would be for 1 year. The board would summons you again after a year to kind of figure out what the status quo is, how everything is, and we could readdress restrictions at that point in time, right?
Could
You
we
have to pay
put some
Mr.
kind of
Katz to show up
guidelines
again.
on like what would qualify a revokement of this privilege? Like, does it need to be a certain amount of violations or a certain?
Well, I think it's all going to depend on the circumstances, right? I mean,
Yeah.
if you guys have an exemplary year, I think the board would be, and I can't speak for the board, I'm just a lawyer, I'm trying to get the process down here, but I think if you have an exemplary year, it goes without stating that the board would be more inclined to remove restrictions or change restrictions than if there are immediate complaints or violations, something of that nature.
I appreciate that, Mr. Braley. Mr. Chairman, if I could just ask,
Sure.
from your perspective, what could transpire throughout the year that would lead to, a sort of a change in this status? And I ask because, if we have a new resident that moves in, like the old resident, who just doesn't like music and wants to call your office every day and complain, and then get his friends to sign into a petition, does that, because I understand, but I just for the record, to try to understand, from the board's perspective, what sort of constitutes violations, if you will?
And I understand that, and I think our chief is a gentleman in all rights and is very fair in adjudicating the field violation, if you will, before it comes to us. And I think those inspectors you see over there, a lot of them have been doing this for up to 20-some years. I think we got right now. If we see, and we know because Michelle and Janet take the phone calls, Eddie and Judy are looking at all these complaints that are coming in. The chief looks at them. If we see a person has moved in the community and then we're getting complaints from this person, well, there's an old saying is, well, it was there before you.
Yeah.
And we've put that into play at times. We said, okay, look, you moved into this situation. The situation was already there. A lot of people moved into it because they like being close to a place like the Point. They want that capability of being able to get off the boat, walk down 2 doors from their house and go into a nice place that they can,
And are we privy to any complaints that come in? Because like a lot of these complaints that were on our record, we had no idea that people were complaining to even maybe make changes to try and talk to them or do something. So is there a procedure or policy set up
and
where
it
we
is,
can be
and
notified?
I'm looking at Chief Ford because it's kind of me instructing him. I think in general, if we get a complaint, we just don't take it and say, oh, it's a complaint, and it goes against them and put it in your file and it sits there until you have hearing. That doesn't happen. That's not, or at least it shouldn't have happened. But I can tell you this, under my tutelage, I would say if a complaint comes in, it's turned over from the administration to the chief to investigate. If he sees something, and sometimes he will confer with our attorney or the administrator or the executive director. If they feel there's some substance to that complaint, he should share it with you, or he should send the inspector out to share it with you.
So if it never makes it to us, even if it's documented in our file, it can't be held against us because we were never told, correct?
I can't speak for...
May I just say one or two things? It's my policy as the chief to err on the side of informing you, of letting you know when there's been a complaint, and having that conversation so that if it is something that needs to be corrected, it can be. And if it's not, at least you're aware that there's somebody out there saying something, and it helps you become better.
We would love that, because like these complaints from 2013 to 16, we didn't know most of them were happening, but now we're sitting here and they're kind of being held against us.
Yeah, and I'm not sure why you weren't informed, or perhaps you were and you don't remember, or whatever the case. I know if I owned your business, I'd want to be aware of any complaints that come in, because I either want to.
Well, I think that at a minimum though, what's being suggested does create a better, more clear standard frankly, for the restrictions, and ones that can be clearly calibrated, which, you know, I think is a lot better than the ambiguity that exists today with the two. So, Mr. Chairman, may I have 5 minutes to independently confer with my client about it?
Absolutely.
Sure.
I could use 5 minutes.
Okay. Okay. Thank you.
Thank you.
Again, inspectors, you are free to leave if you wish to do so. And thank you for staying as long as you have. I appreciate it.
they have, yeah.
Yeah, but you know what we want. The hours that we
Yes.
Okay, so you must know Marita.
Yes.
She's a very, very close friend of mine.
Oh my
yeah,
goodness.
she's like one of my best friends.
She was just at the house for the birthday.
have an opportunity to discuss everything.
I did, Mr. Chairman. And again, we very much appreciate the board's willingness to have this conversation and work through these issues. Same with Chief Inspector Ford and Commissioners Stutes. So we do agree. We would agree to amending the restrictions as suggested. And to just sort of clearly state, we would agree that alcohol sales could not exceed 40% of overall gross sales, and removing the current restriction of in conjunction with, but it be specified that it is this 60, not to exceed this 60-40 split. Secondly, we would agree to a restriction on the music license, which limits, as the code permits, 2 musicians, that the instruments exclude percussion, and but that, and I don't know if this expressly needs to be stated, that they are permitted to play that music through the existing pipe system as long as it's within legal decibel limits measured at the property line.
Also, days and hours that you stated, Tuesday, Wednesday, Thursday, 5 to 8, you plan on keeping that, correct?
Yeah.
Because that would be something we wouldn't want you to wander out of, because that was considered by us when we were thinking about the approval. And if you're okay with that, that's great. I mean,
No, I'm just making sure you guys don't have any live music on the weekends. So, okay, so along with Tuesday, Wednesday, Thursday, not to go past 8 p.m.
okay.
Okay.
And let me just say, off the record or on, because it's a probationary period, you will be looked at, you will be scrutinized. I mean, that's the object behind probation. That's why they have probation officers and things like that. Not to make it sound any worse, but don't be surprised if your inspector or the chief or deputy chief stop by. We don't expect to be sitting there counting heads at the bar. We hopefully have gone beyond that. But I just want you to be aware of it. This next year is going to be crucial for you and for us when it comes time, okay?
Quick question, what email should we send the quarterly reports to? Okay. Okay, I know it well. Okay.
And also, I had a question too, because we are at a marina on the water, that property line. I mean,
What we do with marinas like Nabbs Creek and various places like that over the years is, of course, on land, it's the property lines as your plat indicates. When it comes to, what do you use, the end of the piers or the?
Yeah.
It's the water line.
Okay.
So it's right at the water line. So when you walk down and
So the
you're
water
right at
line,
the edge of the water line.
The bulkhead? You mean the bulkhead or the actual the pier, the furthest pier? I just want to make sure we're measuring it
Yeah,
correctly.
I'm sorry. Yeah,
And it's on the-
where
that's
the
on the-
where the water meets.
That's on the border of our, it's like inside the restaurant, so. It's gonna be, like, it's
You're going to be at
60.
65.
I mean, okay, I'm just saying that might be.
I remember in years past when the inspectors came with decibel measures, they did go out to the dock and measured it from there.
Sure.
Confer with the chief. Should be the same.
Just to find it out.
Just do it. Water line.
We got that straight. Okay, Jimmy.
Right, so I'm just going to put this on the record that there's an agreement that the point will be removing the restriction that's currently on there with respect to alcohol being served in conjunction with food, substituting a new restriction that 60% of sales needs to be for food, 40% for alcohol, not to exceed 40%. The point will provide quarterly statements showing the percentage of alcohol sales versus food sales. And then with respect to the music restriction, that restriction is going to be modified to indicate that 2 acoustic guitar players are going to be authorized with the music to be piped in through the current system, that not to exceed 65 decibels, which is the legal limit. No percussion will be authorized on site, and the music will take place Tuesday, Wednesday, and Thursday from 5 to 8 p.m. Did I miss anything?
On the instrument.
Sure.
Again, I don't want it to just to not to get too ticky-tack, but I don't want. I guess there's an acoustic bass guitar.
Acoustic bass guitar is going to be sufficient as well.
Okay,
That's
okay.
going to be fine too.
Okay.
Okay. Anything else I missed?
Just to clarify, so when the other inspectors were doing the decibel meter from the pier, that's not correct.
We just want to make sure when we're monitoring from the correct spot, because the edge of, there's tables. It's almost in the middle
How
of the
far
restaurant.
is it from land to the furthest point on the pier?
20
It's not
feet.
far. It's more than 20 feet. It's probably like 50 feet. I mean, I could measure it out.
But it's like if we had to go from the water line, you'd be over 65 decibels next to me.
It's just right there in the middle of everything. The crowd will be at least sometimes.
Yeah, to keep things
Just want to make sure we're
pretty much the same with, I'm sorry. No, they're going to be certified.
They'll be certified.
Well,
They
the
agree to
accountants-
that, right?
Yeah, the accounts will send them.
Yeah. What I was getting at is we have other places and we use where the land meets the water. So I think we're going to keep that the same. It's not that much of a difference according to Mr. Jones, so hopefully it won't be a problem. And again, you understand what we're trying to do is make sure you keep your music on your property.
But if you're on the pier and you hear, and the meter reads 65, you're in compliance.
Yeah, absolutely.
Yeah.
If the meter reads 65 all the way at the edge of the
At the edge of the pier, you're in compliance.
right, but it's going to be well, no, it has to be 65 at the property line. If you're at the edge, it's probably going to be the
Could be
exact
less.
same, but yeah, it could be less. I don't know.
Yeah,
Okay.
very seldom does the music or the decibels increase as it goes across the water.
Right.
But it's not uncommon for it to stay pretty fluid.
Yeah.
Because it really, there's nothing there to interrupt it unless you have a bunch of boats out there.
And we will obviously do our best to monitor that. Just for clarity, and if there's anything that comes up, please tell us, and we'll make sure we address it immediately.
And I think the same goes with you all too. If anything comes up, if anything's going to be an issue, please be sure to bring those concerns to the board, to the administration. Okay.
Okay, would you like to read those into?
All right.
There's a motion
I think
for me.
we've already established everything, and we've made an adequate record of it. So if you just want to incorporate those into a motion, go right
Yes. So I'm going to do that. I'm glad we were able to come to somewhat of an amicable agreement. Thank you for that. My motion is that we change the restrictions from what they used to be to what we discussed this evening and agreed upon. And we'll put them in writing also.
Yep.
And make sure you get them. And Eddie, do we issue a new license with new restrictions on it? Is that what's normally happens, or?
I don't know, we can discuss that, normally we would just, yeah, we would have to discuss that, that's something on.
All right, we'll get it straight for you.
We understand.
But you understand what you have to do.
Yep.
And we're going to say this is effective now, immediately, okay? So,
All right, thank you all. very
all right,
much.
with that being said,
Thank you much, Mr. Chairman. Did you
oh,
second?
I'm sorry, I better get to your
Second.
vote. I'm looking for a second. Nope. All this work, and you say nope? Okay, well, with that in a second, all those in favor, aye. Now we can say adjourned. Thank you very much.
Thank you, guys.
Thank you all.